And admit everybody in here. Just Johnny Fawn. Mr. Etheridge, you're here for Mr. Fawn.
Yes, Your Honor.
It's the 7th. All right, so we're on the record in 2600000900. That's People of the State of Michigan versus Johnny Fawn. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Mr. Etheridge.
Morning, Your Honor. Attorney Derek is also public defender on behalf of Mr. Fawn, who is in the courtroom standing to my right.
And sir, you are Johnny Fawn, is that correct?
Yes, sir.
All right, thank you. This is the time set for a probable cause conference. Ms. Fortuna Gill, how are we proceeding?
Your Honor, it's my understanding that Mr. Fawn is in need of a Vietnamese interpreter. It's also my understanding he's had some limited contact with his attorney this morning, but that we would need an interpreter. So I suppose it is up to the court's preference whether we leave it on for next week or we find good cause and reset it for PCC.
I mean, I'm willing to do whatever the parties choose. We could treat the prelim as a PCC and get the Vietnamese interpreter here, or we can just set it, or we can just leave it on for prelim and have the interpreter here. It's entirely up to you. I don't want him to waive anything today unless he chooses to.
I was going to defer to you. So.
Yeah, Your Honor, I would just ask the court to leave it on. I have not been able to talk to him with an interpreter. I did schedule one last week and they canceled, or they said.
I just don't know if we can get an interpreter here in a week's notice. That's my fear. My fear is we've had other interpreter problems, and so, but.
The court would find good cause for that. I mean, I don't want to waive any of his rights, but
yeah,
ultimately, I think it's likely going to be a sobriety court referral anyway.
But right at this point, let's leave it on. Let's leave it on. So we'll leave on for prelim and then see if we can get an interpreter here. If we can't, that would be good cause and we can adjourn it from there. Okay.
So leave on for PE, but treat as a PCC.
Yeah. So we'll leave on for PE, treat with the understanding that we're going to treat it as a probable cause conference. So, and then we'll see if we can get an interpreter here in the next, I think that in the next week it would be. So, okay. Yeah. If it's it would be a Vietnamese interpreter. Is that correct?
Yes, Your Honor.
Okay.
And I was able to communicate with him a little bit via an app on my phone this morning, but an interpreter is much preferred.
Okay, with the understanding that we're treating it as a PCC, but we may get the Vietnamese interpreter here, and then we may be able to go from there. I prefer that to adjourning it at this time for good cause, because we might be able to get the Vietnamese interpreter here. So we'll leave on for preliminary examination. We'll treat it as a PCC, and then we'll be responsible for getting the Vietnamese interpreter here. Anything else for the record in 26000900, Ms. Fortuna Gill?
Not for the people.
Mr. Etheridge?
No, Your Honor, thank you.
All right, Mr. Font, we'll see you next week at this time. So we've set it for May 14th at 8:30, and we're treating it as another probable cause conference to have the interpreter here. Okay, sir?
Yes, sir.
All right. All right, we should be all set. Thank you for your appearance today.
Are you ready on Edwards? I'm going Edwards.
Edwards. Markel Edwards. Mr. Lee, how are you?
Very well, Your Honor. How are you?
Pretty good. All right, so we're on the record in docket 2600967. That is People of the State of Michigan versus Markel Edwards. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Mr. Lee.
Assistant Public Defender John Lee on behalf of Markel Edwards, who was in the courtroom and standing to my right.
And sir, you are Markel Edwards, is that correct?
Yes, Your Honor.
Thank you. This time set for a probable cause conference. Ms. Fortuna Gill, how are we proceeding?
Your Honor, there has been no offer extended on this case. I do not anticipate that there will be one. We're asking that this be left set for preliminary examination next week.
All right. Is that your understanding, Mr. Lee?
Yes, it is, Your Honor.
Okay. So we leave on for preliminary examination set for May 14th. 2026 at 8:30. That'll be live in person on the 6th floor of City Hall of Lansing. Anything else for the record in 26-00967, Ms. Fortuna Gill?
Not for the people.
Mr. Lee?
Not for the defense. Thank you.
We'll
Your
see you
Honor.
next week at 8:30, Mr. Edwards.
Yes, sir.
We are ready on Ennis.
Daniel Ennis. That's Mr. Wanji. All right, so we're on the record in docket 26-00894. That's People of the State of Michigan versus Daniel Harvey Ennis. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Ms. Wanji.
Good morning, Your Honor. Melanie Wanji for Mr. Ennis, who's by my side.
And sir, you are Daniel Ennis, is that correct?
Yes, sir.
All right, thank you. This is time set for a probable cause conference. Ms. Fortuna Gill, how are we proceeding?
Your Honor, the people do not wish to proceed on this case. We have come into some further information and we wish to nolly this case today.
All right. So I'm gonna have at the people's request, and I'm assuming Ms. Wanji has no objection to that.
No,
We're gonna dismiss and we'll have you sign the nolly cross.
If I could spell, that would be nice.
That's
I think that was a prerequisite for this job.
spelling under pressure. Spelling while others are waiting. No, I have the same spelling and typing. Typing, I can't. I'll even say it out loud. I can't type. Yeah. All right, so I'm in possession of the nolly cross on 26-00894. This case is being dismissed by the prosecutor in the interest of justice. So the motion for nolly cross is granted. Which are dismissed without, so it's dismissed without prejudice, which means that people could reissue if they choose to, but realistically, that's kind of a default. Our purpose today, the case is dismissed. All right. I do have a no contact order. I don't have any GPS, so you may want to carry the dismissal around with you just because it takes about 4 hours to purge from the computer system. Anything else for the record in docket 26-00894, Ms. Fortuna Gill?
Not for the people.
Ms. Wanji.
Nothing for the defense.
All right, we'll provide a copy if you want it, just to carry around with you. That's all for the record in 26-00894. Thank you for your appearance today.
Thank you, sir.
And we can go on Hackstead.
That's good. All right, so we're on the record in 26-00801. That is People of the State of Michigan versus David Hackstad. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Ms. Wanji.
Good morning, Your Honor. Mr. Harstad. Melanie Wanji for Mr. Harstad. He's not present.
All right, thank you. This is the time set for a probable cause conference. We previously met on April 16th. At that time, Mr. Hackstad was, it was indicated, was in a treatment facility. So this was reset for good cause. Ms. Fortuna Gill, how are we proceeding?
Your Honor, it's my understanding that Mr. Hackstead is no longer in treatment. I will defer to Ms. Wanji for more information about that.
All right, Ms. Wanji.
Your Honor, it is my understanding that he has absconded
All right.
as of April 24.
All right, so we have not heard, we've had no contact with Mr. Hackstad. Is that correct, Ms. Wanji? All right, Ms. Ms. Fortuna Gill, how are we proceeding? How did you want to proceed today?
Your Honor, the people would request a bench warrant at this time. Considering that the underlying offenses are not assaultive in nature, the people would not object to a 48-hour hold.
All right, I do not see Mr. Hackstad in the physical courtroom, and is there anybody by that name in the physical courtroom? There's nobody by that name in the hallway. I'm gonna have David call the hallway for Mr. Hackstad.
David Hackstad.
It would appear the defendant has failed to appear. I'm assuming after he left the the facility, he didn't come back, or you haven't had any contact with him?
I have not had any contact and the facility has not called me
All
back.
Okay, we'll issue a bench warrant for the fail to appear with a 48-hour hold. And then Ms. Swanji, if you're able to hear from Mr. Hackstad concerning this, you can let the court know, and we'll just leave it on for prelim. But we have not had any contact with Mr. Hackstad, so we'll wait till I think it's Monday. It would be Monday. Anything else for the record? In 26-00801, I've issued a bench warrant with a 48-hour hold. Ms. Fortuna, go.
Not for the people, thank you.
Ms. Swanji.
Nothing, Your Honor. Thank you.
All right.
We should be ready on Alvarez.
Alvarez is on Polycom, and is that Ms.
No.
Donnelly?
He's not.
He's not? Was he brought over?
No, he's not.
He was not? Was
Yes.
he's not from Eaton County, is he?
Yes,
He
he
is.
is.
Oh,
Ding, ding, ding.
all right, so now I recall. So we're on the record in docket 26-01087, that's the people of the state of Michigan versus Jesus Alvarez. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Ms. Donnelly.
Assistant Public Defender Sarah Donnelly on behalf of the defendant Jesus Alvarez, who is not present.
Right, this is the time set for a probable cause conference. There was an indication. So I'll tell you what I know about the file because we've had some discussions on the file. No writ seems to be done as on the PCC. I didn't see a writ in the file, and so I'm wondering if a writ was done on the preliminary examination, because equally I see no writ written in the file. And I know they don't do Polycom out of Eaton County.
No.
So it creates, so we have a problem, and then we have a problem on a problem. So what is my solution is we can leave it on, but I don't know if we can get him writ here in time if a writ hasn't been done. We could also adjourn for good cause because obviously he's not here, but it's not his fault he's not here. And then we can adjourn for good cause and see if we can get him here for another PCC or prelim. It's entirely up to you. How did you want to proceed, Ms. Fortuna Gill? And then we'll hear from Ms. Donnelly.
I truly have no preference. I will defer to Ms. Donnelly.
Ms. Donnelly.
Your Honor, I'd prefer if we just leave it on for the preliminary exam. He was writted over yesterday for a court date in 30th, so I was able to talk to him. We discussed the PCC PE. He agreed to leave it on for the PE, and I'm hoping that we can either writ him in, or there is a chance that he will be released before then as well. So
Okay.
he knows the date, and I've got contact information and all that.
All right. So if he is released, then he may be here.
Yes, just.
I don't know if he'll be writ out because I don't know that I don't know they'll act on a writ within a week.
And if he's still in custody and we can't writ him, obviously, we'll address it.
We'll address it then.
Mhm.
Okay. All right. So let's leave on for preliminary examination for May 14th at 8:30. And we'll see if Mr. Alvarez is able to make it here. Do you want us to, we can attempt to do the writ. I mean, it's 7 days. And they usually ask for 2 weeks, but we can try it just to see, because just to see if we can get him here.
I think it's worth a shot.
Yeah, I mean, it can't hurt, but I mean, what's the worst they can say is no.
Yeah.
You know, I mean, so yeah, so let's see if we can writ him here for the preliminary examination. If he's out, then we know that he's got, you know, that he's got the date, but we'll leave it on for May 14th at 8:30. And he needs to be writ out of Eaton County. All right, anything else for the record in 26-01087, Ms. Fortuna Gill?
Not for the people. Thank you.
Ms. Donnelly.
No, thank you.
All right, we're all set. Thank you for your appearance today.
Billboard?
Hilborn is
or Hillborn.
Hilborn, and he is on Polycom.
He's on post 2, visit 3.
Post 2, visit 3. All right. How are you, Mr. Goodrich?
Doing well, Your Honor. How are you?
Pretty good. All right, so we're on the record in 26-01095. That's People of the State of Michigan versus Benjamin Hilborn. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Mr. Goodrich.
And Luke Goodrich from the Public Defender's Office here to represent Mr. Hilborn, who is appearing over Polycom from the Ingham County Jail today.
And sir, you are Benjamin Hilborn, is that correct?
That's correct, Your Honor.
All right, and you can hear me all right, Mr. Hilborn?
Yes, sir.
All right, thank you. This is time set for a probable cause conference. Ms. Fortuna Gill, how are we proceeding?
Your Honor, an offer has been extended. That offer would be to plead to felonious assault as a habitual second and dismiss the CCW. That offer will remain open until the beginning of the preliminary examination next week. It's my understanding we wish to leave this set for now.
All right, Mr. Goodrich, is that a fair statement? We wish to leave this set for preliminary examination for next week.
Yes, Your Honor.
Examination. So we'll leave on for preliminary examination scheduled for May 14th at 9 o'clock. That'll be live in person on the 6th floor of City Hall of Lansing. Anything else for the record in 26-01095, Ms. Fortuna Gill?
Not for the people.
Mr. Goodrich?
No, Your Honor. Thank you.
All right, Mr. Hilborn, we'll see you next week at 9 o'clock on May 14th. Thank you for your appearance today.
Thank you, Your Honor.
Ready on high or hey?
Frederick,
I don't know.
hi. How are you, Mr. Sards?
Good morning, Your Honor. I'm doing well, thank you.
All right, so, and this is who from the prosecutor's office?
McCray.
McCray. And I have that written down already.
Excellent.
I'll just write it on top. All right, so we're on the record in docket 26-00846. That's People of the State of Michigan versus Frederick. Is it high?
Hey,
Sir? Hey.
Hey, okay,
thank you.
thank you. Appearances for the record, Ms. McCray.
Good morning, Your Honor. Andrea McCray, appearing on behalf of the people.
Mr. Sarts.
Good morning, Your Honor. Jacob Sarge IV, Assistant Public Defender, appearing on behalf of Mr. Haig. I am here in person this morning. Mr. Haig is appearing by Polycom from the Ingham County Jail.
And sir, you are Frederick Haig, is that correct?
that is correct, Your Honor.
All right, you can hear me all right, Mr. Haig?
Yes, sir.
All right, thank you. This is time set for a probable cause conference. Ms. McCray, how are we proceeding?
Thank you, Your Honor. After speaking with brother counsel, both parties have agreed to unconditionally waive their rights to hold the preliminary examination in this case. Consequently, I would ask this court to bind the case over on the charges in the complaint to circuit court.
And is that a fair statement, Mr. Sarts?
Yes, Your Honor. Thank you.
May I inquire of Mr. Haig of his waiver of the preliminary examination?
Please, Your Honor.
All right, Mr. Haig, you understand you have a right to a preliminary examination today. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by attorney Jacob Sarts, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It is my understanding it would be your wish today to waive your right to a preliminary examination, have this case continue in circuit court where negotiations between the parties are going to continue. Is it your wish to waive your right to a preliminary examination today?
Yes, Your Honor.
And as indicated previously, the people also waived their right to a preliminary examination. Is that correct, Ms. McCray?
Yes, Your Honor.
I find the waiver of the preliminary examination to be knowing, voluntarily, and accurately made. And then I will provide the bind over paperwork for signature purposes. And do you allow your attorney, Mr. Sarts, to sign the document on your behalf, Mr. Haig?
Yes, I do.
All right. So I will provide that to my court officer.
court, Your Honor?
You may. Thank you, Ms. McCray. All right, so I'm in possession of the bind over documentation on 26-00846. It's been signed by all the parties. Mr. Hay, you've indicated on the record that that Mr. Sartz has signed on your behalf. Is that correct, sir?
That is correct.
All right. So your time in district court is done. You're off to circuit court. Bond is set at 50,000 cash surety. Any motion for bond in this matter, Mr. Sartz?
Thank you, Your Honor. Yes, respectfully, I would request a reduction in bond at this time. Mr. Hague is not a flight risk. He has connections to the community. He has support, notably his mother. If he was released, he'd have a stable place to stay, Your Honor. He would comply with all Your Honor's orders. He's indigent. He has very limited financial means. $50,000 cash surety is way beyond what the family could realistically afford. This could be quite a lengthy process. There's a lot of discovery. These are complicated allegations, Your Honor. And financially, right now, he just is not in a position to realistically be able to post that cash surety amount. So respectfully, Your Honor, I request a reduction at this time. Thank you.
All right, from the people, I do have a bond recommendation requesting that bond was met. Ms. McCray, you can make a record, or I can rely on the initial bond recommendation. It's up to you.
I would do a twofold. I would ask you to rely on those. I would say additionally, Your Honor, I'm not sure that the defendant could stay with his mother based on the jail calls with his mother. I don't think she is allowing him to stay with her. So that would be news to me. However, beyond that, Your Honor, there's been further investigation on this case. I know last PCC there was a bond motion by both defense and myself. You actually raised the bond after hearing from myself and denied defense's request. These allegations come from the defendant's Google account and the child pornography that was uploaded from his Google account. After a search warrant was done on his phone, let me be clear, of his house, there are several devices seized, including his phone. We found additional child pornography aggravated on his phone, but we also located potential acts of CSCs with a former friend that he used to have, where there were pictures of her asleep or drunk, incapacitated, where he was spreading her anus or other body parts. So we are currently investigating those allegations as well. I would say that $50,000 with all of this, Your Honor, is absolutely reasonable at this point.
All right, and I did raise bond last time to $100,000.
Okay, sure. That's what I thought. I was like, he did less than I wanted.
So yeah, so it was $50,000 was the initial bond set, and then I raised it to $100,000 cash surety. And then whoever wrote down the bond is set at didn't read their ROA where I raised the bond. I'm going to deny bond. There may be future allegations in this matter, so I'm going to deny the request for bond concerning this matter and leave it at the stated $100,000 cash surety. And then this case can continue to circuit court. So your time in circuit court is done, Mr. Hague. You're off to circuit court where negotiations are going to continue between the people and your counsel, Mr. Sartz. Anything else for the record in 26-00846, Ms. McCray?
No, Your Honor, thank you so much.
Mr. Sartz?
No, Your Honor, thank you.
All right, Mr. Hague, you're all set. You'll get your next time to appear in circuit court from your attorney, Mr. Sartz. All right, sir?
All right, thank you.
All right, you should be all set. Thank you for your appearance today. Thank you, Mr. Sartz.
Thank you, Your Honor.
Have we had any indication that Wendell Aldridge is here?
I have not.
So they kind of lost track of him.
Yes. I have not heard that he's here. Mr. Aldridge, have you heard anything? No.
Yes,
We do or don't have a PSI.
I don't believe.
I don't think, I think that's, yeah, I think he missed his probation appointment and,
Yes, he's, I'm sorry.
so did you, is there anybody else you wanted to call?
I
There's
mean,
a Khalil Morgan.
yes, we can handle that. We
All
have
right.
Mr. Lee.
You're all set, Ms. McCray, thank you.
Bye, Judge. It's good to see you. Bye.
Good to see you.
Y'all have a good day. Maybe I should wait.
All right, so let's call, Mr. Lee, we'll call this case, are you on, you're on Morgan? Yeah,
Is he here?
he's on
Or
Polly.
on Polly?
Yeah.
Okay. Lovely.
All right, so we're on the record in 26-00958. That is People of the State of Michigan versus Khalil Morgan. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Mr. Lee.
Assistant Public Defender John Lee on behalf of Khalil Morgan.
And sir, you are Khalil Morgan, is that correct?
Yes, Your Honor.
Thank you. This is the time set for a probable cause conference. Mr. Morgan, you can hear me all right?
Yes, Your Honor. Yes, Your Honor.
All right. How are we proceeding, Ms. Fortuna Gill?
Yes, Your Honor. An offer, or there has not been an offer extended on this case. I do not anticipate there will be. We're asking that this matter be left set for exam next week.
That's your understanding, Mr. Lee. We're going to leave this on for preliminary examination.
Yes, that is my understanding, Your Honor.
So we'll leave on for preliminary examination for May 14th at 9 a.m. That'll be live in person on the 6th floor of City Hall of Lansing. Anything else for the record in 26-00958, Ms. Fortuna Gill?
Not for the people.
Mr. Lee.
Nothing for the defense. Thank
So
you.
I'll see you next week live in person at 9 o'clock on the 6th floor of City Hall of Lansing, Mr. Morgan.
Yes, sir. Thank you, Your Honor, and thank you all.
Thank you.
Yes, sir. Do I just exit out of this video? This is my first time doing this. I'm
Yeah,
sorry.
exactly. You're free to go.
Yes, sir. Thank you.
Mine's on yet.
Doris said he was gonna appear by
It's
video.
early,
Still
so,
got 8 minutes.
yeah.
And then I thought, Green didn't even know if he, but Green didn't think he could bond out, so he must have converted it.
All right. And then
So,
we're Aldridge, we can give, because Aldridge and
then
and
Caswell.
Caswell.
he's on his.
Is Caswell
He's on
in
his
or
way.
out?
Oh, he's on his way from Macomb County.
Carl,
Oh, Calhoun County. Okay. So we are just waiting.
All right. So just come get me
We're
when you're
ahead
ready.
of schedule,
Yeah.
kind of.
Don't know what to do with ourselves.
Yeah, it's nice.
I've gotten to see a lot of Miss Fortuna Gill, a lot of Mr. Smith, because we had a trial Monday, Tuesday, and then we had a hearing go till like 5
Oh,
till
geez.
with Mr. Klug and Mr. That was pro per. They were pro per on those 3.
So 3 long days in a row, so you deserve a chill one today.
Yeah. Barcy was saying we should be able to end the weekend now. You know, and I'm like, yeah, that'd be nice. A Wednesday call that'd be a nice call.
Well, I know
I
Randy had
completely agree.
indicated the exam's not going to run. I believe you already communicated that with Marcy.
Okay.
Our officers are sick, so I think Randy will be here on Zoom.
All right.
But that's not till 11.
All right. So Randy's on the Ruiz case.
Yes.
Okay.
Or yes.
Mr. Behrman.
APA Behrman.
Yeah, that's a reschedule, right?
Yeah,
You
well,
know, when I met APA Behrman, I tried a case against him
oh yeah,
because he worked for Graywall as a defense attorney.
Yeah.
And we did a CSC against, and I'd known him for years, and he was a really good lawyer.
I've learned
So
a
we
lot
kind of
from
stole
Randy.
him.
Yeah.
You know,
He's poached.
yeah, he was taken from the other side, but I mean, I think he was one of, well, he was retained on that case because he was retained. But we didn't have a public defender's office. I think it was one of the best things that happened in this county was getting a public defender's office. Yeah. And at the time that time they legislated that, I think I'm not sure who else had a public defender's office, and it's kind of weird counties. I think Kent County had one.
Before the MIDC.
Yeah,
There-
before
I mean,
that
there was a-
legislation,
They had their defenders offices in like Detroit and stuff. They
right?
weren't-
They weren't.
Yeah, it wasn't a public defender's.
Did Wayne County have one?
Yeah, they were like some of the first to form
Right.
the public
Sure.
defenders counties after MIDC came in too. So
'Cause-
Washtenaw, Oakland, Wayne.
We got Michael Sheltonham from the public defender's office in Alpena, which I was like, I didn't know there was a public defender's, but that was that was late 90s, early 2000s. So he'd come from the public defender's office in Alpena. So it was kind of hit or miss counties that they'd fund,
They
I
would
think.
have, a defender's office. Obviously,
Right.
they weren't public defenders, but like the Detroit defenders and stuff like
Right,
that.
but
Yeah.
they at least gave them a place to congregate.
Yeah.
Yeah, I
So-
think that's really important.
I think I'm a big proponent. I think we probably got it 10, 15 years too late, if not 20 years too late of that legislation. And then that's when all the public defenders, there's still some counties that don't have public defenders.
Yes, Clinton County.
Clinton County, I don't think Midland has one.
Okay.
No. So they still do the court appointed system. I could think of any county this size or bigger, like Flint or Genesee County.
Yeah.
We've got to have a public defender's system.
Absolutely.
So now you're on your third public defender. Yeah, because Russ started it and then it went to Keith and now it's Mr. Cornish. Yeah. So just come get me when you're ready and
Okay,
we'll.
will do. Will do.
And then mark the 18th as, I'm gonna email it out. I'll put you on the email.
Okay.
And I'll put the public defender's office on the email, that I'm gonna take that day off. I haven't seen this person since college. I have seen him via Zoom. We Zoomed together during COVID,
Sure.
just because everybody Zoomed during COVID. But he was my next door neighbor and he was in my wedding.
Yeah.
So,
I'm really sorry.
yeah,
That's
we've
really
we've
hard.
got to kind of, yeah, we went to we both went to college together and we're in high school together. And so, but I haven't seen him I probably haven't seen him since, I was trying to think of the last time I saw him. It's probably been 20 years,
Yeah.
but I saw him via
In
Zoom.
flesh.
Yeah, in the flesh. I saw him via Zoom for months we'd Zoom, all our friends from high school and college would Zoom once a month together. And then we got kind of reconnected. And after that, so I at least got to know what everybody was doing.
That's
So
cool.
yeah,
That's
it was kind of cool. One of the nice things that come out of COVID,
Yeah, that's true.
Yeah, assuming there was a nice thing to come out of COVID, that was the nice thing to come out
Yeah.
of COVID. All right, you just let us know.
Okay.
Mr. Passport has to send this, that is not present this.
This is one of the most disturbing files I've
It
ever
was,
read.
yeah. I don't know.
I
that
know.
information.
I'm glad that we're,
The one.
I did not,
Yeah,
that's what
that's
I
it.
did not want to. I'm glad.
Etheridge?
Over 500.
I know, I'm probably.
Is it now? Because
Oh,
originally when we
gotcha.
first were here, she had
And
100 things.
On the
And then they
other
got-
case has it, my
So-
case has it as well, that was done.
150 files,
6,
Okay.
but this one.
and there were another,
It's dated April 28th.
was not the times,
oh,
but the
they could have charged
is.
280 counts of possession.
This one is.
'Cause there was- Another 280 that they discovered. They-
I don't know what the judge.
that's this
Yeah.
probably the worst I've ever seen since I've been here.
Yeah.
Oh.
I'm so glad we're not seeing.
I'm surprised his bond is as low as it is. 100,000, like.
All of that in front of
I,
think one of them, sure, then one of them must have been mom.
hey, my thing is reality check. I'm sorry. I don't care if that's my brother.
No,
He
yeah.
be sitting here by himself. You get support, when you get support, I will help them drive you to MDOC. That's just horrible. That's That's one of the worst.
Yeah.
As far as volume, one is bad enough regardless, but hundreds.
And imagine Sarts and or Cray has to go down to the office to review what was on.
Yeah, that's horrible.
That's something I'm dreading. This thought so. Something I'll have to do.
It's bad.
Yeah, that I would stay away from that unit for that reason. That sounds horrible.
David, I have a 48-hour hold that I need to do, and can you show me in the office?
Yeah.
I just want to make sure, I think I have notes on how to do it, but,
So he just issued a warrant, right, on that one?
oh no, this was one that's been sitting in the office, so I need to deal with the one from earlier this week.
So
It's 9:30.
when. We have.
Hopefully he's preparing that Zoom right now and they walk away.
That could be true. But then we'll never know. If we're ready.
Yeah. This needs to be filled out by.
Who disconnects the jail polygon?
I have no idea.
Oh, we're not muted by the way, so just so you know, it's
Yeah.
Nice.
So, I figured out that.
we were talking.
Yeah.
Et Gérard. Écoute, est-ce qu'on n'a pas des problèmes par rapport à transporter la boisson dans l'Espagne? Je suis en train de demander s'il ne faut pas demander à avancer l'argent. Merci. Vous aurez vos bagages aussi, non? Est-ce que vous aurez les bagages aussi? Avec les bagages. Ok, mais je veux dire que vous aurez les bagages dans à la malaria. Oui, c'est pour ça que je demande, bon, je vais voyager par train, parce que malheureusement, on va voyager par train, pour être à gauche. Peut-être, est-ce que tu peux demander à la dame du champagne si on peut payer, qu'ils envoient ça directement là-bas? Bon, je vais prendre l'adresse.
All right. The king is here.
How's it going?
King George,
Yeah.
the crazy King George.
Oui, ça nous débarrasse.
We're
Okay.
not muted by the way, so
Oh, good. I was about to say,
and we're live.
I was about to say a lot of bad things.
Good.
I have to be in these things tomorrow. I also have to be here at the same time.
That's a predicament.
So it's pretty bad.
Yes, you do.
Yeah.
Yes.
What's the likelihood of this case going tomorrow?
At 50-50. I
Okay.
told you. I wish I knew too.
It's not a Vila's case, is it?
Mm-mm.
Okay. It just okay.
Yeah, I'm really 50-50. In the past, she's been like,
C'est
no,
Hyundai.
I want to do this. But then
On
the
croit
most
qu'on va en-
recent contact,
Oui, je pense en
Yes.
France.
Kind of thing.
so
Oui, c'est à la
I
frontière.
really
Mais c'est Hyundai, c'est
can't tell
la
you.
Aquitaine. C'est la France Aquitaine.
yeah, we do. Yeah.
Donc, ce ne sera pas comme si on passait par ça va y aller.
I'll see you anymore. Hey, Ben.
I'm gonna try to call her. Oh, sorry to
No,
interrupt.
no,
you.
interrupt.
I'm
Let-
gonna
let
try
me
to
know.
call her this afternoon and I will let
Yeah,
you know what the
yeah.
results of that are.
Because I'd rather be in East Lansing tomorrow because. Want to be in person.
Sure.
Bro,
Yeah. They're crazy, ain't it?
bro,
I think we're not. Are we muted?
we good.
No, we're not muted.
No, I'm about to say all kind of incriminating. I'm
I
about to be held in contempt.
They
Hold
say-
on.
But there's one.
All right, Ms. Fortuna Gill, which case are we calling?
We have Mr. Caswell here.
All right, did you want to do the sentencing first?
They're
Or
both
the-
sentencing.
They're both sentencings.
And Miss Wanji is covering for both of them.
Right, so did you, let's call the first one on 3415.
Oh, the 3415 is a failure to appear. That's Mr. Aldrich.
Oh, I'm sorry, 273.
Yeah.
Yeah. Let's do 273 first. So we're on the record in docket 2600273. That is People of the State of Michigan versus Justin Caswell. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
And Ms. Swanson.
Good morning, Your Honor. Melanie L.P. for Mr. Passport, who's seeking at the council table.
And sir, you are Justin Wayne Caswell, is that correct?
Yes, sir.
All right, thank you. This is the time set for a sentencing in the matter. Ms. Fortuna Gill, is there any other restitution on this file that you're aware of?
No, Your Honor.
All right, Ms. Swanson, have you had the opportunity to go through the pre-sentence report on this file with your client?
Yes, Your Honor.
Any additions, deletions, or corrections?
None, Your Honor. Thank you.
Right, allocution of Ms. Swanson.
Thank you, Your Honor. Your Honor, my client has been in Calhoun County since he was released. Well, since he entered plea here back in, I think it was January. It was January 29. He reported that he has been getting some services there, medical assistance and therapy, and he plans to continue with those services when he gets out of jail. I believe that his out date is May 19. He was very honest with the probation officer during his pre-sentencing interview. He realized that he has some substance abuse issues. He also has some health issues, and he knows that the sobriety is necessary at this time of his life, and he plans to avail himself to other services that would be provided to him. He also planned to apply for disability. I understand that there is a request that I would ask the court to waive the fees for the probation because he is indigent at this time. And we believe that the recommendations are appropriate, and we will respectfully ask the court to give him credit for time served and probation. Thank you.
All right, thank you. Ms. Fortuna Gill, anything you'd like to say to the court before the court passes the sentence?
Your Honor, the people just would like the court to follow the recommendation. Thank you.
All right. All right, so this is for a B&E illegal entry that was pled to on, this entry without permission was pled to on February 6th, 2026. And it's my understanding that Ms. Swanji, the defendant's out date is May 19th. Is that correct?
That's correct.
Okay. All right. So it is the order of the court that the defendant spend 37 days in jail. Credits given for 30 days, 37 days previously served. We'll set fines and costs. So fine at $100, cost at $100, crime victims' rights fee of $75. I'm going to waive the state minimum court cost fee. Probation, I'm going to allow the defendant to pay the fees per probation oversight fee. And I understand he gets out in really about, let's see, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 days. So the defendant may perform 40 hours of community service within, I'm going to say, within 45 days to waive up to, and it would be to waive up to $10 at $10 per hour, to waive up to 40 hours, 45 days, $10 an hour, 8 times 8. Trying to figure out the math here. So it's $10 per hour, 8 days, 7 days a week. 5 days would be 40 hours, 40. So I would think, and I'm trying to find a way to waive the probation fees because it's $300. It'd be $30 per month probation. But if the defendant performs 40 hours community service within 45 days, we can waive up to 40, 80, 120, 160. So he can waive half of that, I think. Waive up to $160 at $10 per hour. So that would be $300 probation, and $160 of that can be waivable within 40 hours of 45 days. There is no assaultive or threatening behavior as a part of this probation. No use of alcohol, marijuana, or controlled substance. Submit to random PBTs and during urinalysis as directed, which seems to be a problem here. And then follow terms of probation for case 25-1930, and I'll write that in the no bars or nightclubs is probably a good idea. And then follow terms of probation. Terms of probation for case number 25-01930, which I believe is the next case we're going to call. So it's no use of alcohol threatening behavior, no use of possession of alcohol, marijuana, controlled substance, submit to random PBTs under urinalysis, and no bars or nightclubs. I'll give you a round number of the total that can be paid over the course of probation. So it'll be 300 plus 75 plus 200 is 575. Maybe that can be paid over the course of the 10 months probation at the request of the probation officer. The probation officer in this case would be Nathaniel Neves. And so he's a pretty easy guy to work with, all right? And then he will bring anything to me if he has any questions, okay? The main part of this is going to be keeping it clean. I mean, that's what most people drop dirty and come to me, and then we start assessing some jail time. I'm not concerned about where you're going to be over the next 10 months because I've kind of got an investment in this. But I'm more concerned that Mr. Caswell makes good decisions 4 or 5 years from now, okay? All right. So I'm going to double check. Yeah. It's 45 to waive it, $310, 40, okay. Submit no bars or nightclubs, follow terms for probation case. All right. Any questions concerning the judgment of sentence, Ms. Wanji or Mr. Caswell, concerning the judgment of sentence? And it'll probably be equaled in the next file that we address. Any questions, Ms. Wanji?
Is alone this case, Your Honor.
What's that?
Earlier release for probation.
Uh,
Does he
oh,
have,
their probation will be at 10 months.
okay, so does he have the right to, the opportunity to request?
Oh, for early release?
Yes.
Talk to Mr. Neves about early release. I think that's available on this file. I don't know if it's available on the next file, okay? But that is something, but if you're looking good after 5 months, it's something we're going to address, okay? Make sure and talk to your probation officer. He's pretty flexible about letting me know, like, this, this can be an early release after 5 months. So it's something, but I don't know what it's associated with. And I think the other one's a use, is the use file. All right, that's a good question. Once you get out, make sure you contact your probation officer, Mr. Neves. Anything else? So I'm gonna indicate that we'll. Anything else for the record in docket 26000273, Ms. Fortuna Gill?
Not for the people.
Ms. Wanji?
Not for the defense, Your Honor.
All right, and then let's call the first one. Let's call docket 25019330. It's got its own precincts. All right, so there's that one for the probation. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Ms. Wanji?
Good morning, Your Honor. Melanie Givenchy for Mr. Caswell, who's seeking out the counsel paper.
And once again, sir, you are Wendell Darnell Aldridge. Is that, I'm sorry, you're not, you're Mr. Caswell. And once again, sir, you are Justin Wayne Caswell. Is that correct?
Yes, Your
All
Honor.
right, thank you. This is the time set for a sentencing in the matter. Ms. Fortuna Gill, is there any further restitution on this matter?
There is not, Your Honor.
All right. All right, Ms. Wanji, if you had the opportunity to go through the pre-sentence report with your client,
I have, Your Honor.
any additions, deletions, or corrections?
None, Your Honor.
Allocution, Ms. Wanji.
Thank you, Your Honor. The same thing that I did, that say on the previous file, Your Honor, I won't repeat it here. I do believe that Mr. Caswell realizes that sobriety is a must at this time because of his health issues and also because he wants to be a good citizen. We would respectfully ask the court to follow the recommendation. Thank you.
All right. Anything you'd like to say on the case from the people, Ms. Fortuna Gill?
Your Honor, the people just request that the court follow the recommendation.
All right, Mr. Caswell, is there anything you'd like to say to the court before the court passes sentence?
No, no.
All right. So this is for a plea to a malicious destruction of personal property, 200 to 1,000, and the attempt R&O. Found guilty on July 21st, 2025 at plea, I believe. Yeah. I'm going to follow the recommendation that has been indicated by probation officer Neves. The defendant is to spend 37 days in jail. Credit is given for 30 days, 37 days previously served. Fines and costs in this matter on there's counts 2 and counts 3. So fines and costs will be $100 fines and $100 cost. Crime victims' rights fee of $75. I'm going to waive the state fee for a $275, placing on probation for 10 months at $30 per month. So that's $300 for the probation oversight fees. And that would, my understanding is that he's going to be on probation, the same probation officer. I'm going to order it, but I don't think that it's ordered on another file, and he's got to follow it on this file. So let's do the $300 probation fee on this file. And then I don't want to duplicate any of the other probation. So, and I think that's already been duplicated because I think I ordered $300 on the other file. So let's order 0 on the other file.
I'll read.
All right. And that, so he would be under 1 probation for the $300 probation. And then he would be under 0 for count 2, which is also placed under 10 months probation. But I don't want, it'd be $900 that's, you know, that's, let's just keep it on one file. So that's $300 per $30 per month. I'm going to put you on probation for 10 months. We have so the fines and costs are $100 fines, $100 cost, $75 crime victims' rights fee, $300 for the probation for $575. And then we'll make the other one, the probation was ordered as 0, just to keep that amount, because we've got 2 files we're working with. On the count 2, which is the attempt R&O, there'll be a $100 fine, $100 costs, crime victims' rights of $75, state fee of $50, for a grand total of $325. I'm going to order 0 on that probation, 0 for the amount amount of probation, since you're already under probation and you have to follow those guidelines. So it'll be for $325. No contact, no assaultive or threatening behavior, no use of alcohol, marijuana, or controlled substance. Submit to random PBTs during your analysis. Since you'll have the same probation officer, that can all be done at the same time. No bars or nightclubs. Part of this is your probation agent has ordered moral recognition therapy, which I probably think is a good idea. And provide verification of disability payment. Not purchase or possess firearms, ammunition, or weapons of any kind. And we'll make that a condition as of the other one also. 26-00273, not purchase or possess firearms, ammunition, or weapons of any kind. And then follow 25-01930, which was indicated on the previous one as part of your terms of probation. That obviously I'm setting probation on this one for 10 months. So Mr. Caswell, you've got some CCH, you know that, and I know that, okay? This is the chance if you've got somewhat of a road ahead of you, okay? But I believe you can do this, all right? And most people come to me when they drop dirty, as you know, okay? You've been on probation before, and this is your chance to shine, okay? Because if you don't shine, you and I know what's going to happen, okay? And this is probably the time to make some of those decisions, okay?
Sir.
All right. So I've set the $575 in total and $325 in total, believing that the probation will be served on this file, will continue with the other file. That's the plan, and I can talk to Mr. Neves about that if he has any questions. There's one added thing to this file, and that is the moral recognition therapy and the proof of disability payment. You can provide that with your probation officer. I've never seen anybody violated on failure to provide payment or anything of that nature. That's our probation department's pretty good about not violating somebody. I have seen violations on dropping dirty, and so that's really the test. If it's not a test, this is your time to shine. Okay. All right. I'm going to sign the order, and then I'm going to make it look all pretty. I'm going to make that one look all pretty too. Anything else?
Yeah.
Let's see, JOS. Anything else for the record in docket 25-01930, Ms. Wanji?
No, Your Honor, thank you.
Any questions concerning the judgment of sentence?
No, Your Honor, thank you.
All right, Ms. Fortuna Gill.
No, Your Honor, thank you.
All right, Mr. Caswell, good luck to you, okay, sir?
Thank you.
Thank you.
Yes.
Yes.
And first one, is that 300 supposed to be right here?
On the 273.
Or 160, I was confused. Remember, at one point you said 160.
Yeah, let's put this on the, because he's got to follow this on 1930. Let's put all this on 1930. Because that's where it makes more sense. Because that's where the probation's put on, but that's where the amount of money, and he should be able to work to put that up.
These stay?
Yeah, everything stays. There's should be zero on
So
probation.
this should be cleared out. Obviously.
Yeah. This should go in the other file. So the file is 1930, which you have. It's the second file we just did.
Right, okay. So it's
Yeah.
this one.
And that's where I ordered $300.
No, so.
And 10 months probation, 300, yeah. Yeah.
So, if the community service was like this.
Yes, yeah, absolutely. And then we're probably ready on Aldridge once Marcy gets,
Sure. We should also have a Mr. Boerma in Zoom. He's an counsel for William Raines or Raines.
we have a Doris, Cameron Doris.
Yes, that is Miss
That's Miss
Donnelly's
Donnelly.
client.
I don't see.
I think he may be in the waiting room.
Oh. Let me admit. And that's for Mr. Raines. We do have Mr. Borma.
Morning, Your Honor.
Good morning. We're going to call your case in just a second, Mr. Borma.
Thank you.
And Mr. Rain, is Mr. Raines here or
Is
is that iPhone 3?
He should be here, Your Honor.
All right.
Yes, Your Honor, I'm here.
All right. And so, sir, you are William Raines. Is that correct? I'm gonna have you renamed here.
Yes, Your Honor.
All right.
Can we look at this when we're done?
Yeah. We've got time to get that to Nathaniel.
Yeah.
All right. So are we ready to go on Aldridge? That's Miss Wanji's client.
We are, Your Honor.
All right.
The people are ready.
All right. So we're on the record in 25-03415. That's people of the state of Michigan versus Wendell Aldridge. Appearances for the record, Miss Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Miss Wanji.
Good morning, Your Honor. May I yield the one from Mr. Aldridge?
All right, this is the time set for a sentencing in the matter. We don't, and it's my understanding, it's my understanding that Mr. Aldridge missed the pre-sentence interview, and so we don't have a pre-sentence for him in the file. It would appear that I do not see Mr. Aldridge in the Zoom courtroom. Mr. Aldridge is not in the physical courtroom. So it appeared that he followed that up with a fail to appear today. You can supplement the record, Ms. Fortuna Gill. and Ms. Wanji, Ms. Fortuna Gill.
That's my understanding as well, Your Honor. The people would be requesting an immediate bench warrant.
All right, Ms. Wanji.
I don't know where he is.
He was in treatment at some point in time in February, and you've had no contact with himself or the treatment center?
No, Your Honor, I
Okay.
haven't.
All right. I'm gonna, and the probation has no contact with him as of May 4th, 2026. Probation Officer Joe Sumter wrote that he missed the appointment set in February. And at this time, the contact was not returned. Defendant has failed to complete the pre-sentence paperwork, pre-sentence interview and substance abuse counseling, substance use assessment. I do not see Mr. Aldridge in the Zoom courtroom or physical courtroom. And at this time, I'm going to issue a bench warrant. So find the defendant failed to appear, and a bench warrant is issued for his arrest. Anything else for the record in 2503415, Ms. Fortuna Gill?
Not for the people.
All right, Ms. Wanji. All right. All right, I've issued a bench warrant for his arrest for his failure to appear. Thank you, everybody, for your appearance today.
Welcome, Your Honor.
And then,
The people are ready on reins if.
yeah, let's go on Mr. Raines. And then we can go on Ms. Donnelly's client. All right, so we're on the record in 2503741. That is People of the State of Michigan versus William Raines. Appearances for the record, Mr. Borma.
Morning, Nathan Burma on behalf of defendant William Raines, who is attending via Zoom for his PCC.
All right, and sir, you are William Raines, is that correct?
Yes, Your Honor.
And you can hear me all right, Mr. Raines?
Yes, Your Honor.
And Ms. Fortuna Gill, I don't know if you got your appearance for the record.
Haley Fortuna Gill on behalf of the people.
All right, this time set for a probable cause conference. Ms. Fortuna Gill, how are we proceeding? Or would you like to defer to Mr. Borma?
Your Honor, it's my request that we leave this set for preliminary examination. I do believe that we can potentially come to some sort of resolution. We have been in talks and will continue to negotiate.
All right, and Mr. Borma, is that your understanding? We're going to leave it on for preliminary examination next week?
Yes, Your Honor. I hope that that in my opinion, the talks have been quite preliminary with the prosecution side of things. But I am hopeful that there can be, a resolution to this. I do have one request. We would like to make a request for an amendment of bond conditions, specifically to allow my client, Mr. Raines, back to the premises where he's sharing a residence with the alleged victim, who's his partner, Sean Wolfert. And it's a request that's been made by both Ms. Wolfert and Mr. Raines, given that there's some medical issues that Mr. Raines has related to his service, service in the military. And so we would like to have that changed as a bond condition if the court is willing to entertain that.
All right, I will entertain it. We will leave on for preliminary examination for May 14th, 2026 at 9:90 a.m. That'll be live in person on the 6th floor of City Hall of Lansing. And Ms. Fortuna Gill, the request for modification of bond, essentially lifting the no contact order response.
Yes, Your Honor, the people would oppose lifting the no contact order. What defense counsel has shared from, as far as I understand, is true that the complaining witness doesn't wish for there to be a no contact order in place any longer. However, it's the people's position that the no contact order is necessary at this point in time to ensure her safety and the well-being of others. The underlying charges here are very serious, and while I recognize and appreciate Mr. Rain's medical ailments that are connected to his service to this country, at this point in time, people would not be comfortable doing that without any services in place.
Oh, all right,
anything of that nature.
for the court to lift a no contact order, and we're considering 2 assaultive crimes, or he was in charge with 2 assaultive counts, I'm gonna need to hear from Ms. Wolford, who I'm assuming would be subpoenaed for the preliminary examination. Is that
She will be
correct?
subpoenaed for the
All
preliminary
right.
exam.
All right,
Already
so,
has been.
so I'm going to deny the modification of bond at this time. But this can be readdressed at the preliminary examination, which is set for next week, May 14th at 9 o'clock. We can, and if Ms. Wolford's here, I would expect her to make a statement concerning, so it's placed on the record, concerning her agreement that the no contact is lifted in this regard. We do have a count 1, assault GBH or strangulation, which is 10 years, and then the count 2 of domestic violence. So I'd have to hear from her if I'm going to modify the bond. So the modification bond is denied at this time, and then we'll leave it on for preliminary examination on May 14th at 9 o'clock. Anything else for the record in docket 2503741, Ms. Fortuna Gill?
Not for the people.
Ms. Foreman, do you have any questions of me?
Do not, Your Honor. Thank you for your time.
All right. All right. We'll see everybody on May 14th, 2026. It'll be live in person on the 6th floor City Hall of Lansing. Ms. Rains, please keep in contact with your attorney, Mr. Borm. All right, sir?
Yes, Your Honor.
All right. Thank you. You're all set.
All right. Thank you.
Your Honor.
Did you want to go on Miss Donnelly's case?
Sure.
Or
Yep.
she's got Doris Anna Green.
I'm ready on both.
All right, let's go on Doris first. All right, so we're on the record in docket 2503403. That's People of the State of Michigan versus Cameron Doris. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Ms. Donnelly.
Assistant Public Defender Sarah Donnelly on behalf of the defendant Cameron Doris, who is appearing separately by video.
And sir, you are Cameron Doris, is that correct?
Yes, sir.
And you can hear me all right, Mr. Doris?
Yes.
All right, thank you. This is the time set for a probable cause conference. Ms. Fortuna Gill, how are we proceeding?
Your Honor, there has not been an offer conveyed on this case. I do not anticipate there will be one. We're asking that this matter be left set for preliminary exam.
And is that a fair statement, Ms. Donnelly?
It is.
All right. So we're gonna leave on for preliminary examination for May 14th.
Yep, we're good.
At 9:30. That'll be live in person on the 6th floor of City Hall of Lansing on May 14th at 9:30. Anything else for the record in 2503403, Ms. Fortuna Gill?
Not for the people.
Ms. Donnelly.
Not for defense.
All right, Mr. Doris, we'll see you next week at 9:30 live in person. All right, sir?
All right. Have a good one.
All right, thank you.
Yes. Okay.
And then,
You go on green.
all right. Pamoja?
Pamoja.
Pamoja.
Yeah.
All right. All right, so we're on the record in docket 2600774. That is People of the State of Michigan versus Pamoja Green. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Ms. Donnelly.
Assistant Public Defender Sarah Donnelly on behalf of the defendant who isn't present.
All right, and Ms. Fortuna Gill, how are we proceeding? This is set for probable cause conference.
Yes, Your Honor, the people would request a bench warrant. However, considering the underlying charges, the people would not oppose a 48-hour hold.
All right, I do not see Ms. Pamoja Green. Is Pamoja Green a sir or man?
No, it's a man.
Okay, I do not see I don't see anybody by that name in the Zoom courtroom. Nobody's answering by that name in the hallway, Mr. Pamoja Green, and nobody's in the hallway. It would appear the defendants failed to appear for the probable cause conference. Miss Donnelly, have you had any contact with Mr. Green?
Yes, I have, Your Honor. He was given a 10% bond, and so I talked to him last week while in custody. He didn't think he was gonna be able to post bond, so we thought he was gonna appear here by writ today, but he was released on the 2nd. He is from Detroit. My concern was that he was released and he had no one to contact to let him know where he was. I don't know where he is. His mother is in Detroit. She answered the phone and says she hasn't heard from him, but she would obviously, have him call me if she does. So.
All right, so we've somewhat lost contact with Mr. Green, but we'll issue a bench warrant with a 48-hour hold, and that would allow Miss Donnelly any contact she has with Mr. Green to let the court know. We'll just leave it on for preliminary examination next week.
Yes, Your Honor.
All right, so I'm going to indicate that the defendant has failed to appear for the PCC, and we'll issue a bench warrant with a 48-hour hold. And if Miss Donnelly's able to get a hold of Mr. Green, we'll just set it. We'll just continue on for prelim for next week. Anything else for the record in 26-00774, Miss Fortuna Gill?
Not for the people.
Miss Donnelly.
And not for defense.
All right, we're all set on that file.
Mr. Gomez.
And is Mr. Gomez incarcerated?
Yes.
And is he joining us by Zoom or is he coming?
Let me check.
I think that he's supposed to be on Polycom.
I don't see him on, but
this is supposed to be here to go.
But I've got 2 posts and they're both.
One of them is, it keeps packing up because they make more. I don't know.
Is there anybody in post 1 visit 6? Or I don't see anybody in post 1 visit 7. I think they're both empty at this time.
I'm gonna call out there, Judge.
All right.
Do you know who you're looking for?
Mr. Gomez.
Yeah, Theodore Gomez.
And was he supposed to appear by Polycom? Is that in jail?
Yeah, I think
He's not in jail.
he's not in jail.
Well, I have the Polycom list. Let me see. Theodore Gomez, 9:30.
I think that's somebody from the jail saying
He was
something.
supposed to be in from post 1 visit 4.
Post 1 visit.
But now the 10th, they probably put Rick White in there for judge board. So you might want to contact post 1. Do you have that number?
I think that David was calling.
Okay, yeah, David should have the number.
Yeah. I think that noise is coming from outside of post.
Yeah, I think outside the door.
Visit 7, yeah.
Our intention is to just leave it set.
All right, so let's see if we can get Gomez here. And then Savannah Ruiz is Mr. Johnson, and that's Mr. Berman.
Yes, and Mr. Berman will be on Zoom.
Okay. You can probably do this.
I can do this.
If you can finish this thing.
I just want to make sure I'm doing it right.
Ms. Sutter, how are you?
I'm well, Your Honor. How are you?
Pretty good.
If you don't mind, if you have just a minute, I was going to introduce you. We've got some interns starting with us. So we are joined by Sylvana James and Cole Edgecombe.
Pleasure. You're always welcome in this courtroom. So.
Well, Cole specifically is being assigned to your courtroom.
Okay.
So he's going to be working with Tyler and James in here.
All right. We need all the work we can get. we're happy to have anybody come and help us. You'll learn a lot on the 4th floor. I mean, I think you do. We've got good lawyers, we've got good judges. But you're going to feel like a sponge the first 2 or 3 weeks.
I told them a lot of things.
Yeah, there's just a lot of volume. We just have a lot of volume in comparison to other cities our size. We have a lot of volume because we're a smaller city, but we have big city problems. Okay, I guess that's the best way to put it. But you're always welcome. You're always welcome to wander around the 4th floor and see. There's 4 courtrooms here. So
We're in the sixth floor.
we're in the sixth floor. What did I say, the fourth floor? The sixth floor, yeah. You're always welcome to wander around the courtrooms and see what's going on.
Thank you.
Okay.
So Judge, they said they were doing meal prep right now, and they don't have anybody available that can call in, so we'd have to call them, but I told them practices that they call us. So I don't know how you wanna, they said it could be a little later, but
We can leave it on for next week.
Yeah, we can waive his appearance and just leave it on for next
yeah, 'cause
week.
this is
Yeah, so let's do that. And this is for Mr. Gomez. All right. We know where he is. So, all right, so we're on the record in 25-02426. That's people in the state of Michigan versus Theodore Gomez. Appearances for the record, Ms. Fortuna Gill.
Excuse me. Haley Fortuna Gill on behalf of the people.
Ms. Wanji.
Good morning, Your Honor, and yet we want you for Mr. Alcrest, who's not present.
All right, this is the time set for a probable cause conference. It's my understanding for Mr. Gomez, it's my understanding that he is to be put on Polycom. We know where he is. He's incarcerated and they're having some meal prep issues.
they just updated me, just said, I guess now they are calling me.
They're gonna call him in? Okay.
Oh,
Now we're waiting.
Yeah, let's wait a minute for him to
Sure.
get here and then,
Right, I'm muting, or I'm pausing.
yeah, I'll know when.
Okay, so back to.
And here's Mr. Berman here. Okay.
My question is on this part, so I'm.
So sir, are you Theodore Gomez?
Yes.
All right.
Good.
then you let me know when we're ready on that one. All right. So we're back on the record in 25-02426. I believe the parties have made their appearances for the record. And sir, you are Theodore Gomez, is that correct?
Yes, sir.
And you can hear me all right, Mr. Gomez?
Yes.
All right, this is the time set for a probable cause conference. Ms. Fortuna Gill, how are we proceeding?
Yes, Your Honor. The people would ask that this matter be left set for preliminary examination. The people do intend to run this preliminary examination. There are no offers.
All right, and is that a fair statement, Ms. Wanji? That's your understanding?
It is, Your Honor.
Okay, we'll leave on for prelim on May 14th at 9:30. So we're leaving this on for preliminary examination for May 14th at 9:30. That'll be in person on the 6th floor of City Hall of Lansing. Anything else for the record in 25-02426, Ms. Fortuna Gill?
Not for the people.
Ms. Wanchi?
Your Honor, there is an unusual issue in this matter. The family had contacted me because my client's car was impounded. And there are some tools that are very expensive inside the car. And I don't know how we can manage to get those tools. I've never had this kind of problem, but my clients would like me to address that to the court.
All right, Ms. Fortuna Gill, has any of this brought to your attention concerning clothes in the car? I would think that the car tools.
Yes.
So it would. So the tools would be in the car. The car is is obviously contraband in this.
Right.
But the tools in the car would be, that might be addressed at the preliminary examination. I'm uncertain, but I'm sure the prosecutor. I'm sure we could facilitate the tools if that's a problem.
Yes, Your Honor. This is the first I'm hearing of this, but I have no problem reaching out to LPD and seeing what we are able to do.
All right. So the vehicle, of course, is considered a part of the dangerous weapon, but
Yes.
anything in the vehicle or the tools could obviously be used if they're not contraband themselves. LPD's not keeping them as evidence or something along those lines. So I'll let Ms. Fortuna Gill and yourself speak on that. And then if it needs to be readdressed, we can readdress it at the prelim next week.
Thank you, Your Honor.
All right. Anything else for the record in 25-02426, Ms. Fortuna Gill?
Not for the people.
Anything else, Ms. Wanchi?
Not for the defense.
All right. Mr. Gomez, we'll see you live in person on May 14th at 9:30. You should be all set.
Okay.
I will let you know if it's in.
Yes, thank you.
No, no worries.
All right. And then Mr. Johnson, you're here on Ms. Ruiz.
Yes, sir, Your Honor.
Set for 11. And Mr. Behrman, you're here on that case also. Is that correct?
That is correct, Your Honor.
All right. Ms. Rees isn't here, but she's got some time.
Yeah, but I just spoke to her. She is on the way. Let me check.
All right.
And if the court is,
if we're just putting her
at 10:58, she texted me that she was 5 minutes out.
All right. So she's got till 11:15. So we'll give her 15 minutes grace time on that. So Mr. Berman, we'll call that case in about 10 minutes.
That's fine, Your Honor. She showed up all
right.
the other times.
Yeah. So, all right. So, and if you haven't, so we'll call that case at 11:15. All right, Mr. Behrman, we'll call that file of 26-00168. That is People of the State of Michigan versus Savannah Nicole Elizabeth Ruiz. Appearances for the record, Mr. Behrman.
Thank you, Your Honor. Randall Berman on behalf of the people.
Mr. Johnson.
Good morning, may it please the Honorable Court, Kareem Johnson, appearing on behalf of Ms. Ruiz, who's seated to my immediate right.
And ma'am, you are Savannah Ruiz, is that correct? All right, thank you. This time set I have it set for preliminary examination today. Mr. Berman, how are we proceeding?
Thank you, Your Honor. I know this case has been adjourned numerous times. I think it's mostly, if not every previous time, been done at the request of the defense. This time it's on the request of the people. I received word yesterday late morning from Sergeant Scott Williams with the Michigan State Police that he was sick and had no voice. And I waited a little bit throughout the day, didn't hear back from him that he had been feeling any better. Reached out to defense counsel in the court and advised that I was going to cancel witnesses and that we would get a new date for preliminary examination. We could have everyone testify at the same time. I have extended an offer to Mr. Johnson. I know he's still looking at the file as he's relatively new on it. I think he wants to look at a couple other pieces of media evidence on it, and quite possibly the case next time we show up will waive. If not, we'll be prepared to run it.
All right, and my understanding is that Ms. Ruiz did waive her 21-day rule on January 29, 2026. Is that your understanding, Mr. Berman?
That is my recollection, Your Honor, yes.
All right, and that's your understanding, Mr. Johnson, is that correct?
Yes, Your Honor. Just looking for some body camera
footage,
which I do not have in my possession. And Your Honor, quite frankly, we'd ask the court to set the matter for PCC. You know, based on the charges and what I know now, and how that would affect my client's sentencing guidelines, it would be highly unlikely that we would not waive and accept the offer, Your Honor. Just one thing I have to double check.
All right, so Mr. Berman, we can set it for PCC and set it for prelim both. With that, so we set it for PCC and prelim a week later. Mr. Johnson was not involved in the case. Well, I'll leave it up to you, Mr. Berman. Would that suffice to set it for PCC and then for prelim?
Makes 100% sense to me, Your Honor.
All right. So we'll set. So based on the request, this adjournment is at the request of the people, and we'll set it. And it appears that there's no objection. There are some discovery issues, and there was a request we set it for PCC first. We'll set it for PCC for.
Do you want 2 weeks or 3 weeks?
I'd hear from the parties because they have the discovery issues, and then you've got to review the material.
I think 2 weeks should be fair, Your Honor. It's just I don't know if the people have the body camera footage or if they get it from the Michigan State Police, but they typically get it to me within 24 hours. And I just let Mr. Berman know I didn't have it yesterday.
Okay.
So I would say 2 weeks in, that's enough time for me to view it, talk to my client, and make the decision out.
All right. So, Mr. Berman, the discovery issues, 2 to 4 weeks?
Yeah, 2 weeks ought to be fine, Your Honor.
All right.
I've watched the video. I'm surprised that we didn't send it. I can't tell from my file if it's been transferred or given a download to Mr. Johnson. But as soon as we're done here, I'm going to follow up with my office to make sure he gets what he needs.
Okay. So we can set the probable cause conference for the 2 weeks.
May 21
So May 21st.
at 9:30.
At 9:30, and then let's set the preliminary examination the week following. I don't know if that's a Thursday or a Friday. Let's see. Or PCC. I think it's on a Thursday. The 28th is on a Thursday.
Yep. And that will be at 2.
Okay.
28th at 2.
So May 28th at 2 o'clock for the preliminary examination. So based on the fact that the defendant has waived their preliminary examination or waived their 21-day rule on January 29, 2026, and it requests to the people without objection, and we have some discovery issues that are ongoing, we've set the PCC for May 21st at 9:30 and the preliminary examination for May 28th at 2 o'clock. Anything else for the record in docket 2600168, Mr. Berman?
No, Your Honor, thank you.
Mr. Johnson, anything else for the court?
Yes, Your Honor. The 28th, I will be in a jury trial in Presque Isle County. But again, it is 95% likely that this is going to waive.
Okay.
So
Do you want to leave that on? Do you?
Yeah, I'll leave it on.
Okay.
Yeah, sure.
Okay. With the understanding that councils may be, Prescott County is about 4 hours away.
Yes.
But you'll let us know if we need that date, we can move it.
Yes,
Okay.
sir.
No problem.
So we'll make sure but I will say that there may be a conflict with another county. Anything you'd like to say on that, Mr. Behrman?
I have no issue with that. And if Mr. Johnson sees something in the video that he's unhappy about, he can just call me. We can discuss it through anyway,
right.
so.
All right. We'll leave it on set for the prelim set for May 28th at 2 o'clock and wait to hear from council. Anything else for the record in 2600168, Mr. Berman?
No, Your Honor.
Mr. Johnson?
No, Your Honor.
All right, Ms. Rees, we'll see you live in court. The PCC can be via Zoom on May 21st at 9:30. We'll see you live in court on May 28th at 2 o'clock. Thank you for your appearance today.
Thank you, Your
You're
Honor.
all set, Mr. Berman.
Thank you, Judge.
Oh, dates on it.
Oh. Yeah, it's got both. Okay. I need just one more.
Yeah. Kareem,
Yes, ma'am.
that, the first date, the May 21st, if you can write on there, it can be in Zoom.
Yeah, that can be via Zoom.
The 28th date is in person.
Right, we have Mr. Woods for sentencing at 1:30, and then the rest are civil and.
Yes.
Thank you. Okay, thank you. Wait. It's blacked out, so they shouldn't be able to see. It's District Two residents. There's nobody on it, right? No. Oh, why did they do this? Well, hello, sir. All right. It offered this. Yeah, that's yourself. I can't complain. I mean, I guess I could, but am I going to? How, how this will spend. Yeah. Let's be drunk for a second, but that's over. Okay. Yeah. Close out. So on. Yeah, just yeah, people trying to impress. I got you. You in particular. But that's not good. That makes things a little bit easier to deal with and manage stressful situations of living, causing them stress. Good. Okay. Do you do anything in particular in it, or did it just kind of dissolve itself on its own? Kind of just dissolve itself. Okay. Is there anything doing? Good. Also, the tension that's going on. Oh, that makes more sense. There's a hearing going on it.
Holy, so I'm getting around in the seat and get rid of it. You know what? That's. Your insurance not recording, is it? Because of the private therapy sessions, so they should. It's fine, but. But there's nobody there. Okay, well, we'll keep an eye on it. If he comes in, that's a problem because. It was so, I don't know what's going. Yeah. Oh, okay. Okay, I don't even know what they, I've never had that before. Oh, okay. But then I get sentenced by first and supposed to be trying to serve. Okay. And I plead guilty to something. Okay. My, lawyer said, so. Yes, yes. Somebody else was, here, and I think that I had to taser. Okay, so when I didn't see. That's what they put me back on. That's how I'm charged with something to taser. Okay. So I just said, I pled guilty when I was in the court. I had it in my hand. Right. I mean, I'm not gonna deny that it was in my hand, so. Yeah, I do. I had it in my hand. Right. I told them that I had it in my hand. Right. To the other guy was like, it was in my hand. Yeah. Right hand. Makes sense, right, literally. Yeah. So PSI, you've never done one before? I'm talking about something frustrating, so I don't even know if it's for the, presentation. So you can tell. So ish. Okay. Officer. Yeah. It is, so I will be checking to make sure that wants to see any of the on, give this to them by 2 o'clock. TV is still on. Oh, thank you so much. Yeah. Yeah. For. That should be for whatever your sentencing is gonna be for on July 1st. Yeah, so that should be for the July 1st. Oh. Well, I don't know nothing. I don't have all this. Right here, that's the one. It's like you can pick like that's the problem. Talk about it, right? That's worker. Cause I was talking to you.
All right, do we have a representative of Credit Acceptance Corp. On 25-7-215, that's Credit Acceptance Corp. Versus Tierra Harris Holbrook.
Good afternoon, Your Honor. Sazan Barta, P65425 on behalf of Credit Acceptance
right.
Corporation.
And all I'm doing is making sure I know who's in the Zoom courtroom, and then we're going to call cases in a little bit.
Thank
But
you.
thank you, Mr. Barta. All right, and then it's two. Then we have LV. Who's here for LVNV funding? All right, so do we have a representative of LVNV funding? Is that you, Miss Bailey?
Yes, I have LVMV funding versus Shambrika Simone.
All right, so you're here for your 2 o'clock.
And Shabrika is here at Zoom.
All right,
Hallways empty.
and then are you here also on the Brian Rodriguez case, Miss Bailey?
I am.
And
Okay,
he's on Zoom.
all right. And then Mr. Smith, are you here on the McKissick case also?
I'm here on Demaria Morgan, Lamia McKissick, Latia Henry, and Eddie Montalvo Villasenor.
All right. And those are 2:30, and then this one's Lamia McKissick is 2 o'clock. So on the Samsung, could you please identify yourself on the Samsung cell phone? Could you please identify yourself? You'll have to unmute on the Samsung cell phone. You'll have to unmute and identify yourself. But on the Samsung cell phone, I'm. Okay.
Can you hear me now?
What's your name? What's your name?
Ladero Kimball.
You're here for your 2:30, Mr. Kimball?
Yes, sir.
All right. I'm gonna have you rename because you're.
I got it.
All right. And then I'll call your case around 2:30. You're set
Do
for
I sit
2:30.
here? Do I sit
Yeah,
here
you're in
or
the
do I-
right place. You're in the right place.
All right. So just mute
You're
my
just
mic.
you're about 20 minutes early.
Okay.
All
So
right.
I leave out and come back?
No, you can stay right here. You just have you just put yourself on mute. I'm gonna put you on mute. So we're on the record, Mr. Smith. We can call your first LAFQ case. We're on the record in 170047467. That is LAFQ versus Demaria Morgan. Appearances for the record.
For plaintiff LAFQ, Tim Smith, P48259.
And ma'am, you are Demaria Morgan, is that correct?
Correct.
All right. So you can.
I'm sorry, dude, that was my ear. I got the wrong.
And you can hear me all right, Miss Morgan?
Yes, I can.
All right, thank you. This is the time set for, I have it set for a motion. We previously met on January 20th, 2026. I don't know, is that Judge Babcock's signature? It doesn't look like, but it was
Judge Babcock. Yeah, Judge Babcock handled the January 20th show cause for failing to produce.
All right, there was a parties period resolution between parties D to produce payroll, last month account, statement, D to pay $125 2 times a month. Motion to show cause was withdrawn. Mr. Smith, how are we proceeding today?
We, following that January 20th hearing, I got in writing to Ms. Morgan, and Your Honor, just as a heads up, this dates back to a summer of 2025 subpoena that we've been trying to get compliance with document production. We had a control date last September, another control date last October. Judge Babcock was kind enough to give her even more time to produce documents. I got in writing to her. She had recently opened up accounts at Huntington. She was to produce monthly account statements from Huntington. She was produced payroll, pay stubs. Since that date, we've received nothing, which has been this defendant's position. in just refusing to produce documents and frustrating the entire discovery process.
Ms. Morgan, you've not provided any discovery process to the plaintiff?
Not since January 20th, but there was one time where I came to court and it wasn't Mr. Smith that I was at court with. It was a lady and she allowed me to email the documents.
What date was that, ma'am?
I could not tell you.
Because I don't have anything on the file that predates January 26th. January 20th of 2026 was the last that Judge Buchanan, and then there's been nothing been done on the file since that date to today's date that I can see.
Yes, the defendant just stated that she's done nothing and produced nothing since that January court date, Your Honor. And that January court date was a motion to show cause for failing to produce. Here we are nearly, 4 months later? Not a single piece of paper, not a single document.
Ms. Morgan, it appears that you've kind of admitted to the show cause in this matter. I don't see that any documentation has been provided to Mr. Smith. Mr. Smith, how did you want to proceed today?
I think if the court would be willing to entertain this approach, we'll give her 7 days to produce the Huntington records and her payroll. Failure to produce those within 7 days results in a bench warrant.
Ms. Morgan, you understand you have 7 days to produce the documents that have been indicated. The 7 day, if the documents are not indicated, are not produced, the court will sign a bench warrant for your arrest. Do you understand that?
Yes.
All right. Ms. Morgan, this case has been going on. It looks like it was initially set at 2018. We were caught up. It looks like the parties appeared in front of me on June 30th, 2025. So there's been ample time to make the discovery request. I will sign an order for bench warrant if not produced in 7 days. Do you understand that?
Yes.
Do you plan on producing the documentation for the plaintiff?
Yes.
Okay. All right. Well, I'll wait to hear from you, Mr. Smith, whether we need, but we'll let's set it for a control date 7 days from today's date. How does that sound?
Is there a way I can get documents of how much my loan is now?
I want all documents that's been indicated are to be produced.
But Ms. Morgan, if you need an account balance, if you need to know how much you paid to date since entering that judgment, you need to know the current balance of the judgment, you can call or email me. You have all my contact information. I can get you to the penny, everything.
Okay.
You got 7 days on the documents, or I'm submitting a warrant to the court. And Your Honor, let's not do a control date. I don't want to have to come back for the, 6th or 7th time on the subpoena. If I don't have the documents in hand in 7 days, I'm simply submitting the warrant.
All right. All right. So we'll have 7 days to produce or warrant to be signed.
And you've got my number, Miss Morgan. You should call me.
Okay.
Okay. This has been going on since June 30th that I've had the opportunity to look at the file. We're here on 31st, on the 11th, on the 28th, on the 28th, I have one entry on the 28th, one entry on January of 2026 and May of 2026. So at least I've been on the file since the 2025, and then it looks like it started back in 2018. So please contact Mr. Smith. You understand the severity that we're dealing with, and I will sign the order at the request of counsel. So you have 7 days to produce. Anything else for the record in 1700467, Mr. Smith?
Nothing for plaintiff. Thank you, Your Honor.
Ms. Morgan, do you have any questions of me?
No, thank you.
All right, you should be all set. Thank you for your appearance today. So I still don't see Miss Patrick, so I'm going to go on the next case. 7215. This is, you're working on this, Marcy, so I can't get on it. It's 7215. It's got you. MAK is already working on this document.
I told you.
Yeah, exactly. Oh. All right. That won't give me anything.
It didn't give you.
No, but let me do the primary review with that. Now we're good.
I was gonna say, I logged all the way out.
All right, so we're on the record in 2507215. That's Credit Acceptance Corp. Versus Tierra Harris Holbrook, and you are Tears. You can have a seat right here. Appearances for the record, Mr. Barta.
Good afternoon, Your Honor. Suzanne Barta, P65425 on behalf of Credit Acceptance Corporation.
And ma'am, you are Tierra Harris Holbrook, is that correct?
Yes.
All right, thank you. This is time set for a motion. I think this is a motion for summary disposition. Is that correct, Mr. Barta?
That is correct, Your Honor.
All right. I don't know if the parties have had an opportunity to speak to one another. Did you just want to go forward with the motion, or did you want to speak with Ms. Harris Holbrook?
We can go forward with the motion. She's not going to lose any leverage in resolving it, no matter what happens today.
All right. You can go forward with your motion. I did have the opportunity to see the motion and read it. You may go forward, Mr. Borda.
Thank you, Your Honor. The motion is based on MCR 2.116 C9 C10. There's no genuine issue of material fact for this court to decide at a trial. It's a straightforward collection matter for a vehicle on a retail installment contract, a 2015 Buick Enclave. Attached to the motion, we have that contract. We also have the itemized statement of the payments made, the auction of the vehicle, the proceeds of that auction that go towards the vehicle. Defendant has not filed a response to her motion, and pursuant to Michigan court rules, she must do so. And also her answer doesn't even answer any of the allegations in our complaint. All it says is that we can take this to court. So there has been absolutely nothing for this court to decide. I believe our motion should be granted at this time. Thank you.
And I was able to read the answer to the initial complaint, and there was indication there was not a denial of the complaint. It was simply there's no money. The money wasn't there to make the payment. Was that your reading, Mr. Barta?
The answer that
it was a handwritten letter.
Yes, I handwritten a letter because I couldn't afford it anymore, and they repossessed it from my possession. So
that's the letter you're speaking of in response to the answer. Is that correct, Mr. Barta?
The answer that I'm speaking of was February 12th, and all it says is I'm writing this to want to let you guys know that we can take this to court. I will see you then. So that's all it says.
There's another full page letter. I thought maybe, okay.
no, it was just this one.
All right. Ms. Robinson, do you have the motion for summary disposition is a motion of matter of law.
Mhm.
And do you have any response to Mr. Barta's motion as a matter of law for the motion for summary disposition?
So I'm confused on what we're trying to do.
Yeah, this becomes a collections issue if I rule for him.
Yeah, it's gonna be a collection because it's on my credit. So
Okay.
I understand that part, but at the same time, I can't afford to pay any collections. I can barely afford my rent or groceries.
Do you owe the money?
Yes, I do. I can admit that I owe the money because I was sold a junk car and I put $5,000 up for the car and it's in the things. So, and when I reached out to them and told them that multiple times I could not afford it, they repossessed it.
All right. So I'm gonna grant your motion for summary disposition.
I ain't got no money to pay, Your Honor. I'm just gonna say that I'm struggling as it is right now. I don't even have groceries in my house right now.
Disposition.
So if they want it, they can have it.
So I'm gonna grant the motion for summary disposition. You'll follow that up with an order, Mr. Barta.
Yes, sir, right away.
All right, and then now that I've signed, when I sign the order, it becomes more of a collections issue, okay?
Okay.
But this will indicate that you owe the amount of money that they've indicated based on the ledger you've been provided.
That's fine, but they're not gonna, I don't have no money.
This is just a formality.
Yeah.
Just for formality, we go through the process. They've got to get the order signed and then they can collect on the order.
They can try to collect whatever. I only got a 7-year-old and some clothes they can have. That's all I got. I ain't got nothing else.
So, Mr. Barta, I will grant your motion for summary disposition and I will await the order to follow. Anything else for the record in 2507215, Mr. Barta?
Not at this time, Your Honor.
I have a question.
Miss Harris Holbrook, do you have any questions?
I do have a question because they are saying the car was in good shape when they gave it to me, correct?
Right.
That's what they're stating?
They're indicating you owe some money to them.
Yes, but the car that they gave me was not a good car.
Okay.
Like, it was a lot of work that needed to be done to the car.
It's kind of after the fact since I've granted the motion.
Well, this is not, I've never done this, but at the same time, if they want to take me and get the money, they're not gonna get it. And I'm saying.
That's part of the collections issue.
Yeah, apparently this don't be collected then. I don't know.
All
what
right.
to tell
Well,
because
I mean,
run
that's a whole different,
And the
that
same
may be
thing
in front of another judge and maybe in
Yeah,
front of me.
because the
okay?
same thing that he got is I got too, and he know how the car looks and he know how it was sold.
Okay.
And the person that sold it to me, he knew who he was selling to me too after I wasted $5,000 on a car that barely even ran. And I was still paying on top of it $390-some a month.
All right.
So, but hey, it is what it is. Catch me in traffic, I guess.
All right. So I will sign the order to follow, and that's all for the record in
I'm ready to go.
2507215. Thank you for your appearance, Mr. Barta. Thank you for your appearance, Miss Harris Holbrook.
Thank you, Your Honor. Can I go now?
You're free to leave.
Thank you.
So you should be all set, Mr. Barta. I'll sign the motion when the order when it's presented to me.
Thank you, Your Honor.
All right, and then are we ready to go on Mr. Liddell Woods?
Yes, sir.
All right. All right, so we're on the record in docket 2600472. That is People of the State of Michigan versus Liddell Woods. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Ms. Patrick.
Good afternoon, Your Honor. Melissa Patrick on behalf of Liddell Woods, who is here to my right.
And sir, you are Liddell Woods, is that correct? All right, thank you. This is the time set for a sentencing in the matter. I have the JOS here. Is there any further restitution in this matter that you're aware of, Ms. Fortuna Gill?
There is not.
Ms. Patrick, do you have the opportunity to go through the pre-sentence report with your client?
I did go through the pre-sentence report with Mr. Woods.
Any additions, deletions, or corrections?
The only thing that I can, there are no factual corrections. We went over everything, but I would like to speak about the meeting between Mr. Woods and the drafter of this document.
All right. So as a part of allocution, you can talk about the meeting that himself and Ms. Bayless had. But as far as the document itself, there's any deletions, additions, deletions, or corrections, or I can write down any edits or would be taken part of the record.
Right. There's nothing.
All right. Allocution, Ms. Patrick.
Your Honor, at this time, Mr. Liddell wants to withdraw his plea.
mainly because of this meeting with the preparer of this document. I think there may have been some kind of misunderstanding. I think Mr. Woods had his child with him. I think the meeting just was probably not ideal for either parties. And he just wants an opportunity to possibly redo his interview with this person and start all over again, Your Honor, get
What
another chance.
he's not going to get the chance to see her if he withdraws his plea, because then it'll just be placed on part of the pretrial.
Right.
There was a Killebrew agreement of YTA.
Yes.
And that's not being recommended.
That is correct.
So the recommendation is to follow the Killebrew agreement. And the recommendation for the probation department is to deny YTA at this time. And that was that's part of the agreement that I see. It was Killebrew to YTA.
That's correct.
So the request is to withdraw his plea.
Yes.
for if I'm going to follow the recommendation.
Correct.
Which I would tell you I was going to follow the recommendation. Okay. So you're going to have the opportunity to withdraw your plea if you choose to. Would you like to withdraw your plea today?
Yes.
Okay. All right. So we're withdrawing the plea so the plea is withdrawn. I'm going to say that all parties are appeared. I'm not following the Killebrew agreement. I'm going to set a bond in this matter because bond was previously set at a PR bond, and I do not think that's sufficient. So I'm going to set a bond in this matter, but all parties appeared. Defendant withdrew plea. And I'm specifically indicating because the recommendation is a violation of the Killebrew. The Killebrew is requesting YTA, and I'm not granting YTA. So Killebrew, HYTA, not followed. And we will reset for a pretrial. Well, we reset for probable cause because it's a felony. So we'll reset for a probable cause conference. Bond is set in the matter, and I'll set the same. The bond is set at $1,000 cash surety. The same bond conditions apply that applied at arraignment, and so there'll be no use of alcohol or drugs without a prescription, no out-of-state travel, no possession of a firearm. And possession of a firearm means that if you're released, you have to submit an indication that you're not in possession of any firearm to the city of Lansing. Okay, and Mr. Wormsley is going to take it. You're going to find out about that form. We're going to give you the form, so you'll come back and you'll indicate that you're not in possession of firearms. Okay. If you are in possession of firearms, they have to be removed from your office. I don't think that applies in this case because it's an attempt RO, and that only applies to a CSC, a stocking. It's brand new. They just made the law.
Okay.
So I don't think it applies for this case. So I'm going to indicate, just for the record, that you're not to possess a dangerous weapon or firearms, but that doesn't apply to you. Okay, I just rethought that whole thing that I just said doesn't apply to you.
So,
but you're not to be in possession of a firearm or a dangerous weapon as part of your pretrial condition.
So it's $1,000 cash.
$1,000 cash surety. So so it's got to be set. There's got to be a cash surety component to it. So it would be it'd be $1,000 cash or a surety bond, whatever the bondsman decides to put up. And then report to pretrial services within 48 hours of your release. Okay, because I'm setting bond at 1,000 cash surety. We'll reset the probable cause conference for. Yeah, I think I think it'd be required 2 weeks, at least 2 weeks for the prelim. I don't know if you need 2 weeks for the probable cause conference.
next week.
Yeah, we can do next week for probable cause conference. And then the witnesses will be subpoenaed at prelim. So is that the 14th or 15th for probable cause?
Probable cause would be the 7th. Oh, wait, that's okay.
Yeah. That's,
That doesn't work. I can't do it. So we're looking at.
okay. So we'll set the probable cause conference for May 15th at what time? 9:30. Okay. And then we'll set the preliminary examination.
That would be. Right?
Yeah. That'll be 2 weeks. So we can put on the 22nd.
And let's do that at. Prelim, let's do that at 10.
At 10 o'clock. All right, we've set the probable cause conference for May 15th at 9:30, and we've set the preliminary examination for May 22nd at 10 o'clock.
I'm sorry, Your Honor. I was chit-chatting with my client. Can you tell me those dates one more time?
Absolutely. We can, the probable cause conference is set for next Friday at 9:30. It's May 15th. And then the preliminary examination is set for May 22nd at 10 o'clock. And that'll be the following Friday.
Thank you.
All right. Anything else for the record? So we've reset the probable cause conference and the preliminary examination. Anything else for the record in docket 2600472, Ms. Fortuna Gill?
Not for the people.
Ms. Patrick?
No, Your Honor, thank you.
All right. We'll see you on next week's date. Thank you for your appearance today.
Okay. Thank you, Your Honor. Have a good afternoon.
You too, Ms. Patrick. I'm gonna put the judgment, the older judgment of sentence, I'm gonna tear up, and then we'll just give probation back their file, okay?
Thank you.
All right. All right. All that was Mr. Barta's case. All right, Miss Bailey, you're here for LBND funding, is that correct?
Yes.
All right, so let's call that. So we're on the record in docket 2600353. That's LVNB Funding LLC versus Shambrika Salmon. Appearances for the record, Miss Bailey.
Kara Bailey, P73071 on behalf of the plaintiff today.
All right. And you are Shambrika Salmon, is that correct?
Yes, it's currently Mac, but it was formerly Simone.
It's formerly Simone. So it's Shambrika Simone, and you'd like to be referred to as Shambrika Mask, is that correct?
Yeah, yes, yep. I got married, the name change.
All right. Thank you. This is the time set for a pre-trial in the matter. And as in all the cases, I will allow the attorneys, I can facilitate a meeting in a breakout room between counsel and the attorney, and we can have some discussions concerning the legal issues that led to the filing of this complaint if you choose. If not, I think I can just fill out a pretrial statement today. It's entirely up to you, Ms. Bailey. Since you're the moving party, how would you like to proceed?
Well, it's a pre-trial. I mean, I usually leave it up to the defendants whether they'd like to speak to me in a breakout room, because if they don't want to speak to me, it's not going to be productive. So. All
right, Miss Mask, would you like to speak to Miss Bailey before this pretrial statement is really a scheduling statement? It's actually called a scheduling statement in some courts, but this is actually a scheduling statement that we put down. Would you like the opportunity to speak with Ms. Bailey, who's a legal representative of LVNV funding.
Yes.
Okay. All right. So I'm going to indicate for the record that all parties appeared. And we are going to meet in a breakout room. All right. So let me add that note and I gotta make some rooms here. I don't see any. All right, so Miss Bailey, you will get a prompt to go to room 1. And Miss Mask, you'll also get a prompt to go to room 1. And we'll come back and put it on the record. All right. And we're on the record in docket 2600863. That is Credit Acceptance Corp. Is that might be, no, Credit Acceptance Corp versus Brian Rodriguez. Appearances for the record. Do we have a representative of Credit Acceptance Corp? Do we have Brian Rodriguez here?
Yes, you do.
I have checked. That might be Miss Bailey might be here on that case.
I believe so.
All right. All right, stand by. We'll let Miss Bailey come out of the breakout room on that case. And let's call the next case. So we're on the record in docket 2601082. That is Lafque versus Lamaya McKissick.
For plaintiff Lafque.
Appearances for the record, Mr. Smith.
For plaintiff Lafque, Tim Smith, P48259.
And on the iPhone, are you Lamaya McKissick? You just moved your phone?
This is Edward Cade. I'm sorry. If you're talking to me, Your
Edward
Honor.
Cade.
I got it.
All right. Is there, Mr. Smith, do you see a Lamaya McKissick?
I do not, Your Honor. I did speak with Miss McKissick since she was served with the summons of complaint, and then she filed an answer, and her answer basically says, I owe it, I need a payment plan. I had sent her a consent judgment with a $150 a month payment plan as she had requested in her answer. I haven't received it back. What I would propose in light of her failure to appear today, we're here for the pretrial, is that we enter a default for failing to appear, but give her the courtesy of the installment payment plan language within the default judgment as she requested in her answer at $150 per month. We can start that June 1. If the court's okay with that, I'll prepare and submit it.
All right, I'm okay. That works for me. So I do not see Lamaya McKissick in the Zoom courtroom. I see no Lamaya McKissick in the regular courtroom. It would appear to me that Lamaya McKissick has failed to appear for the pretrial. And so I will grant the default. I will grant the default for the fail to appear. but then you have some timing, you can submit it, you can submit the default, or you can send the consent judgment. You have some authority
We've
to submit
sent
it.
it to her, Judge. We don't have it back. So that's the
Okay.
issue. So I'd like to do the default judgment. We'll put the installment plan, the payment plan language in the judgment at the requested amount from her answer at 150 a month commencing June 1, and we'll prepare and
All
send
right.
it to the court.
All right. All right. So I'm going to grant the default judgment for the fail to appear, and I'll await the order to follow. And then there's going to be language in the default judgment which talks about, so I'm not surprised when I see it, which talks about the terms of the consent agreement. Is that correct?
Yes, there'll be a payment plan provision at 150 per month beginning June 1.
Okay. Okay, so I'm going to place there will be language in the default judgment for the fail to appear concerning the agreement. So if I look back at my notes, because I'm signing a bunch of documents, I'll understand what you're doing here, Mr. Smith. We're going to grant the default judgment, but we're going to place language concerning the settlement arrangements in the default judgment, and that I think that should suffice.
Okay. Yep, we'll prepare and submit, Judge.
All right. Anything else for the record in docket 2601-082, Mr. Smith?
Nothing for plaintiff. Thank you.
All right. You should be all set. Thank you for your appearance today.
Yeah, I'll sit you.
Okay.
Have that Monday.
And Mr. Chernich, you're here for Case Credit Union?
Yes, Your Honor. Scott Chernich on behalf of Case Credit Union.
All right. And I do not see, is there an Angela Downs? I don't see an Angela Downs here for discovery.
Angela Downs?
So this was scheduled 2:45. All right. Did you want to call your case, Mr. Chernich, or do you want to wait for Miss Downs? She's got 15 minutes grace time that are up right now.
Yeah, Judge, this is a discovery hearing.
Correct.
And, I think that if I can just shed a little light on this, I believe that Miss Downs moved out of state. We've got proof of service by way of certified mail. So if the court wants to give her a little more time, that's fine. Either way, I'm here.
Yeah, I've given her, she's got 15 minutes of grace time is what the court usually allows. And so I'll call that case. That's 1702281. That's that's Case Credit Union versus Angela Downs. Appearances for the record, Mr. Chernich.
Good afternoon, Your Honor. Scott Chernich on behalf of Case Credit Union.
All right, and Angela Downs is not in the Zoom courtroom and not in the physical courtroom. We've called her name in the hallway. It would appear that Miss Downs has failed to appear today for the discovery hearing. Mr. Chernich, how would you like to proceed today?
I think there's a proof of service in the file, Your Honor, and I would ask that a bench
There
warrant
is.
be issued on show cause, depending on which way the court usually goes on these things.
We usually go with a show cause, and I don't think she's been show caused yet. I think this is the first time. So let's show cause. So I'll set it for show cause hearing. And this, I think the civil department, do we set that or the civil department set that? I can't remember. We'll set it. We'll set it. Civil, okay. So the civil department will set the show cause hearing on that, and then we'll go from there, Mr. Chernich. But I have issued a fail to appear for her fail to appear, and then we'll set it for show cause hearing. So if she shows up, she can explain herself. If not, then at that hearing, we'll decide where we go.
I appreciate that, Judge. Just to sort of dot the i's and cross the t's. I will say that the proof of service indicates that she's residing now at 1398 Cuprum Pass in Fort Wayne, Indiana.
Yeah, that's our last address with her is in that it is that exact address.
Okay, well, I just wanted to make sure we're serving in the right place. So I appreciate that,
All right.
Judge. Thank you very much.
All right. Anything else for the record in 1702281, Mr. Turnus?
No, Your Honor. Thank you very much.
Okay, you're all set. Thank you for your appearance today.
Yep.
And then Mr. Smith, you're here on that Monteballo Villa Senor case. He was asking to move it, and we never heard back from him. I don't know, Mr. Smith.
He's zoomed in, Your Honor. We
All
went
right.
through a lot of effort to accommodate him for a 3:30, but I see him on the Zoom right now.
All right, so we're on the record in docket 2100418. That is Lafque versus Ed Montalvo Villasenor. Appearances for the record, Mr. Smith. Appearances for the record.
For plaintiff Lafque, Tim Smith, P48259.
And sir, you are?
I'm Eddie Montalvo Villasenor.
Okay. Eddie Montalvo Villasenor.
Yes, sir.
All right. All right, this is the time set for a discovery hearing. I see that we previously met. And then let's see, plaintiff service was not. So service was made because we have Mr. Montalvo here. It looks like that was the previous in November. Mr. Smith, for this discovery hearing, would you like the opportunity to speak with Mr. Montalvo Villasenor? I can place him under oath, and then you can proceed with your debtor's examination if that's part of the discovery.
That would be great. And a little direction from the court. I anticipate some pushback from this defendant, but just reminding him about what information he has to divulge to me in the examination once we retire to the breakout room.
All right. Mr. Montalvo Villasenor, you understand that I'm going to place you under oath, and you're to answer Mr. Smith's questions for this examination. This is part of the discovery process. If you don't coordinate part of this with the discovery process, then we don't have Mr. Smith doesn't have the information he needs, then we can't go forward. Then we're going to have everybody here, and we're going to show up, or we'll issue a bench warrant for your arrest. Do you understand that, sir?
I filed a motion to set aside the default judgment, Your Honor, due to sewer services.
That's not what we're here on. We're not here on your motion. We're here on this discovery that started in 2023, and that's what we're here on. So if you did file a motion, I don't have any indication of that, sir.
Okay, well, I just filed a motion as soon as I was aware of the court date.
Okay, well, you should follow up with the civil department in 54A as to what happened to that motion, because I have no
the
motion.
21st at 1:30, sir.
Yeah, well, I'm not going to argue with Mr. Montalvo. I'm going to place you in a debtor examination, and I'm going to swear you in, and then you're going to answer Mr. Smith's questions. If you want, nothing has been set aside. No order has been set aside. I don't have that. What I do have is a discovery that was set for May 7th, 2026, which is today's date. All right. So if you want to find out what happened to the motion, you should probably contact the civil department.
I did.
Do you understand that, sir?
I did, Your Honor.
All right. So please raise your right hand, sir.
I don't want to provide any information to Mr.
Please
Smith.
raise your right hand, sir. It's part of the discovery process. If you're not going to take place, we'll just issue a bench warrant.
To take place for what, Your Honor? I'm here.
For your discovery proceeding, I'm raising your right hand so you can take an oath, so I can put you in a room with Mr. Smith and he can ask you some questions concerning this discovery hearing. If you're not willing to do that or take an oath of any type, you don't have to take an oath, but you have to say that you're going to tell the truth, then you're not answering the discovery proceeding, and we'll issue a bench warrant for your arrest.
Okay. So, if certain questions he asked that I don't feel comfortable answering, what about that?
I don't know what questions he's going to ask.
He asked personal questions that I don't feel like giving to him.
I don't think Mr. Smith has ever asked personal questions other than financial questions that are part of this discovery. But let me swear you in, and you can answer the questions if you have a problem answering any of those questions. All right. Okay. Raise your right hand. Do you solemnly swear affirm, tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, sir.
All right. I'm going to indicate that. So I'm going to place you in a breakout room with Mr. Smith.
Your Honor,
So,
before we go to the breakout room, I need you to instruct the defendant that where he works, where he does all of his banking, where his accounts are located, that all of that information is information he is required to divulge today.
That's absolutely true.
Okay.
Everything Mr. Smith just indicated, you must provide that for discovery purposes concerning this debt.
And may I ask why?
Because the law requires it. That's why.
So, and you were saying if there was questions I didn't feel comfortable in answering, then what were you saying?
Well, those aren't personal questions. Where you work, your finances, things of that nature, those are all discoverable.
Then why is he asking
If you're not going to answer the questions, we'll just come live in person on the 6th floor and go from there.
Today? Would you like me to head there today then? I don't know.
No, I'm going to set it. I'm going to give you a date. Mr. Smith can attend via Zoom. And that way I have my court officer here. We can, if you are still refusing to answer questions, we can have you arrested and we can place you in jail.
Yeah, I just want to know what's going on because like I said, I don't even.
Look, I'm telling you what's going on. You have to answer questions. You've just taken the oath. You have to answer questions. If you're not going to answer questions today over Zoom, then I can have you here. I can have Mr. Smith here. We can put you on an iPad. You can answer the questions. If not, we're going to set a bond and we're going to place you in jail.
Even though after I told you that I never received any paperwork about.
Those are your options. Those are your options. Which would you prefer to do? Do you want to attempt to answer Mr. Smith's questions, or do you just want me to set a control date and set it for hearing in front of myself?
So, if you were to set a
those are your two options. Those are your two options. You can answer questions today, or you can come in person and answer questions. And if you don't answer questions, we're just going to arrest you.
Okay. And what was the, if I was to come in person, what date was that you said, Your Honor?
I have not set a date for it yet. Is that what you're choosing?
I would probably rather to do that because like I said, I don't.
All right. So we're going to set a control date and we're going to adjourn this matter. This discovery hearing, because Mr. Montalvo is also obviously not going to abide by the request, the discovery request. So we're going to just adjourn the discovery hearing. We're going to have Mr. Montalvo live in person. Mr. Smith, you can come via Zoom. And then if you need some time, we will readdress it on the record, and then I can place him under oath, and then we can place him on an iPad if he chooses that. If not, we'll have security and security here, and we can take Mr. Montalvo. I can set bond that you're requesting for the non-compliance in the discovery matter.
Thank you, Judge.
All right, and we'll set that for yeah. Go ahead. May 29th. 1:30. May 29th at 1:30.
Okay, Your Honor.
All right. So, Mr. Montalvo, Bill Senor, you'll be live in person on the 6th floor City Hall of Lansing on May 29th at 1:30. Mr. Smith, you can attend via Zoom, and we'll put him on iPad if he chooses that route.
Thank you, Judge.
All right. Do you have any questions for me, Mr. Montalvo Villasenor? May 29th at 1:30, that's live in person.
Yes, I do, Your Honor. So you stated that you're not aware of our court date on the 21st of 1:30?
I have no motion set.
I do see it on the 21st.
On the May 21st at 1:30. So it is in the computer that on May 21st, I'm going to entertain a motion on this case.
Thank you, Your Honor.
Okay.
What we
So
might
that-
do,
that
Your
has
Honor,
been-
just as a matter of efficiency, what we might do, I've already filed an answer to that. It's a motion, it's some papers that he filed. What I would suggest on the 21st is that we hear that first, you make a ruling. This is what he called earlier his motion to set aside default judgment, which is really not what it is. But once you rule on that, presumably deny it, we could then conduct the creditor exam at that point in time. But why don't we have the defendant appear live for his motion on the 21st?
Well, it doesn't, I've set it for the 29th. We can put everything on the 21st to hear it right after the motion. That's
But
Mr.
make him,
Smith is
but Your Honor, make
indicating.
him come, he's going to need to come live
Yeah.
for the motion on the 21st.
Because what we're doing is a week later, we're going to be entertaining a discovery request, depending on what happens in that motion. So, so let's make that motion live. May 21st, we'll make that motion live. So we'll do the
For
live.
both parties, Your Honor, because I was told I could do it via Zoom and they provided me with the Zoom number.
All right, I'm telling you that Zoom is unavailable, and you should be here live May 21st at what time? What time is the motion set for?
It's set for 1:30, Your Honor.
Okay, so we'll make that a live motion for 1:30. Mr. Smith, I'll leave it to your option. You can come via Zoom or you can come in person to that. That might facilitate you talking to Mr. Montalvo. If that doesn't work out, but we are set for a live motion on May 21st at 1:30.
Thank you, Judge.
All right, so Mr. Montalvo, I will see you live May 21st at 1:30 on your motion. And then that may, depending on how I rule, but that may question whether we have a May 29th hearing date. I'll let you know on May 21st.
Thank you, Your Honor.
All right. All right. Anything else for the record in 21-00418? That's all for the record in that file. Thank you, everybody, for your appearance today on that file.
Thank you, Judge. Your Honor, I had another matter. That was my 2:30. I had a 2 o'clock McKissick, MCK.
Yes, that's the one that was the
Oh, that we already did that
default?
pre-trial. I had Latia Henry at 2:30 as well.
Yes, I can call that. I've got 3 more set at 2:30. I can call Miss Henry's case right now.
Thank you, Judge.
All right.
Your Honor, mine are both set for 2 o'clock, and I have a
All right.
resolution on the one you sent me for the
I'll
breakout
sit
room.
tight so you can handle the 2 o'clock.
All
Your
right.
Honor.
So Miss Bailey, you were here, and then I think, are you on the you're on the first LVNV funding, is that correct?
Yes, LVMV funding versus Shabrika Simone.
All right, and then who's here on the Credit Acceptance Corp versus Mr. Rodriguez?
That's mine as well.
All right, that's just double checking. That's what Mr. Rodriguez said, and so I was just double checking that. Okay, so we're on the record in docket 26-00353. That is, so that's the original with Miss Mask.
Yes.
Okay, so on the record in docket, 26-00353. That is LVNV Funding LLC versus Shabrika Salmon, known as Miss Mask now. And Miss Bailey, did you have the opportunity to speak with Miss Mask in a breakout room?
Yes, and we did come to a resolution, Your Honor.
All right. Did you want to place any of those terms on the record?
Yes, my intention is to put the consent judgment on the record, get her consent to sign it and e-file it today.
All right. Miss Mask, you understand Miss Bailey's asking to sign on your behalf in advance to the court for the court's signature. Do you understand that, ma'am?
Yes, absolutely.
And is that all right with you?
That's totally fine.
Okay. And you understand the terms of the agreement that you've entered into with Miss Bailey, is that correct?
I do.
All right. So I will await the order to follow. The terms were placed on the record concerning Miss Mask indicated that you can sign on her behalf to advance to the court after the parties met in negotiations. Anything else for the record in docket 26-00353, Miss Bailey, on that file?
No, Your Honor.
Okay, and you'll follow it up with an order concerning the agreement between yourself and Miss Salmon.
Yes, I will e-file a proposed order.
All right. Miss Salmon, any questions of me?
I just want to know, do we need to put on the record the amount, or that'll just come with when I get it in the mail?
It will be advanced. Miss Bailey can put the terms of the agreement on the record if she chooses.
I can do that, Your Honor, if Miss
Okay.
Mask is more comfortable with that. That's not a problem.
All right. What are the terms of the agreement, ma'am?
So we are entering into a consent judgment for a total amount of $1,069.67. That's $896.11 in principal balance, plus costs in the amount of $96.56. That's a $56.65 filing fee and $41.91 in service costs, and then a $75 statutory attorney fee. The total judgment again is $1,069.67, and that does accrue interest at the statutory rate. The defendant's going to pay the judgment at a rate of $40 a month starting June 15th, and the $40 due on the 15th of each month thereafter. The agreement does not suspend any annual filing of a garnishment against the state income taxes, just the wages and the bank garnishment. If a defendant fails to abide by the consent judgment, the plaintiff shall file an affidavit of noncompliance with the court, whereby the terms of the agreement shall be set aside without further court hearings. And it instructs the defendant where to make the payments.
All right, Miss Mask, is everything that Miss Bailey just placed on the record, was that part of your agreement?
Yes.
All right, and you've given authority to sign on your behalf. Anything else, Miss Mask, concerning this docket 26-00353?
No, Your Honor.
Okay, I'll await to sign the order to be presented by Miss Bailey. That's all for the record on 26-00353. Thank you for your appearance, Miss Mask.
Thank you, Your Honor.
And then Miss Bailey, I'll call your next case with Mr. Rodriguez after give me about 10 seconds.
Okay.
Excuse me, Judge Flores. Excuse me, Judge Flores. Can you hear me?
Mr. Montalvo, I'm doing another hearing now, so I'm unable to speak to you.
I apologize. I just was making sure it's good I can hang up this call. I'm sorry.
You can hang up. You're good to go, sir.
Okay, thank you, sir. Thank you, Your Honor.
All right, so we're on the record in 26-00863. Thank you, Marcy. That's Credit Acceptance Courts versus Brian Rodriguez. Appearances for the record, Miss Bailey. And now you're on mute,
Sorry,
ma'am.
forgot I muted. Kara Bailey, P73071 on behalf of the plaintiff today.
And sir, you are Brian Rodriguez, is that correct?
Yes, sir.
All right, thank you. This is the time set for a discovery hearing in the matter. Miss
Your
Bailey,
Honor, I
what I
believe
can
it's our motion.
Oh, it's
Sorry, I
let's
believe it's
see.
our motion for summary disposition.
Mr. Rodriguez. You are correct, ma'am. You are correct. I was looking at another case. All right. So we're here on a motion from credit acceptance court for motion for summary disposition. I would give the parties this is from Miss Bailey's. If Ms. Rodriguez, do you want to speak to Miss Bailey about the case, about the conditions that led to the motion, or do you want to go forward with the motion? It's entirely up to you.
I don't know anything about this. I'm completely confused. So I'll leave it up to her.
All right, Miss Bailey, did you want to go forward with the motion, or did you want to meet with Mr. Rodriguez?
I believe it's sufficient to go forward with the motion at this time.
All right, you may proceed, ma'am.
Your Honor, this is our motion for summary disposition under 2.116. This is a simple collection matter, a retail installment loan for a vehicle. The motion has the retail installment contract attached, as well as the accounting of payments and fees accrued, which include what was received in the auction, as well as the fees incurred in the auction. The balance due on this retail installment contract is $12,967.16. Mr. Rodriguez, in his answer, does not dispute that he had the contract or owes the money on the contract. He also has not responded to our motion pursuant to the court rules, and therefore we are asking that our judgment that was submitted with the motion be entered at this time.
All right, thank you. Mr. Rodriguez, your response to the motion for summary disposition, this is a motion as a matter of law, and I don't have a response from you.
I would have paid for this truck, but I lost my job and became homeless for a while. As soon as I can find work again, I would be more than happy to pay for it. But I haven't been able to find work.
All right. So this was the letter I was talking, the answer, it's handwritten, I believe. Is that correct, sir?
Yes.
All right. So Mr. Rodriguez is indicating that it's not that he doesn't owe the money, he can't pay at this time. With that understanding, that's the response of Mr. Rodriguez. I'm going to grant the motion for summary disposition as a matter of law. And then it turns it, Ms. Rodriguez, what it'll do is turn it into a collections issue, essentially. So you'll prepare an order to that effect, Ms. Bailey, of granting the motion for summary disposition.
I believe an order was submitted at the time I submitted the motion. I can resubmit it if the court would like.
I would resubmit it just to be careful.
Okay, no problem. It's still saved. So
yeah, and because I'll remember it, I can look at my notes. If it comes as a part of something, I don't know that I always get that. That's just been my experience.
No problem. It will only take me a minute to refile it, especially since I'm going on there for the other case too.
All right, so we'll grant the motion. Grant the motion for summary disposition, and the order is to follow. All right. So anything else for the record in 2600863, Ms. Bailey?
I do not believe so, Your Honor.
All right. Mr. Rodriguez, I'm going to sign the order when it's presenting, granting the motion for summary disposition, indicating that you do owe the money. It's just that you can't pay the money. And then it turns into a collections issue after that. Okay, sir?
All right.
All right. That's all for the record in 2600863. Thank you, everybody, for your appearance today.
Thank you, Your Honor.
Take care.
Thank you, Mr. Rodriguez. Now we can go on Lafque and Latia Henry. Okay, so we're on the record in docket 25-07291. That is Lafque versus Latia Henry. Appearances for the record, Mr. Smith.
For plaintiff Lafque, Tim Smith, P48259.
And ma'am, you are Latia Henry?
Yes, sir.
All right, thank you. This time is set for a pretrial in the matter. As always, I would give the opportunity to the parties to speak if they want to speak about some of the issues that led to the filing of this complaint. I can also do a pretrial statement, which is really a scheduling order that I would allow Ms. Henry, because she said I'd like you to see it, and then you could sign it. Mr. Smith, it's entirely up to you as the moving party. How would you like to proceed today?
Well, she did file an answer. She doesn't dispute the debt. She just wants to cap the amount owed and start payments on it. The terms that she offered in her answer weren't acceptable to my client. But if she would like to talk, we would be able, we could discuss potentially a dismissal of the case, a conditional dismissal with a payment plan on the entire amount owed. If that's something she'd like to discuss, maybe she can get an iPad. But if she doesn't have any interest in that,
the numbers that appeared that you offered to Mr. Smith, he's looking for different numbers, but he would talk to you about that. We could place it on an iPad, and we could give you some privacy, so you could talk to Mr. Smith and negotiate. If that's going to be fruitless because you're indicating you want to go to trial on this, then I'll just fill out the pretrial statement.
No, I didn't say I wanted to go to trial. He said something about a dismissal.
A conditional dismissal. I think Mr. Smith can explain that to you. That
I would like to know about that.
Okay. So those would place some of the, you could dismiss today, but there are conditions for the dismissal, and the case can be resurrected if those conditions aren't met. I think that's the fairest way to put it.
Correct, Your Honor.
So I'll let Mr. Smith talk to you about that, okay?
Okay.
All right. So Mr. Smith, we'll place that in abeyance and we'll put it on an iPad. And I'm gonna put you in room 1, and then I'll put the iPad in room 1.
Thank you, Judge.
Wait on the iPad.
Wait on the iPad.
Yeah, because Star has one of ours.
Which one did David have? David had one.
Well, you'll see one that when he.
All right, whatever shows up, I'm gonna put in room 1.
Yeah, whatever he logs into Zoom, that's the one. The other one is. And one of the weddings this year.
Okay. They're just gonna have to wait their turn.
Yeah.
All right. I want to make sure I've got. All right, let's see if we can do this next. Let's see who's here. All right, 26-0. So Mr. Nixon, you're here on JP Morgan Chase.
Yes, I am, Your Honor.
All right.
JP Morgan
Just making
Chase.
sure all right. So, and that is, and I'm sorry, you can say that again?
It's Chase versus David Hopkins, I believe.
All right. And you are Mr. Hopkins, all right?
Yes. No. I'm representing Chase Bank. My apologies.
Right.
I guess
right.
I didn't.
Mr. Hopkins is in the courtroom. Is we have David Hopkins, we have Billworth Lyman.
No, that's the wedding.
Okay, that's the wedding?
Yeah.
Okay. Couldn't tell.
For the one sitting out.
All right, and then Mr. Cade, you're here on your case, and that your case is with Ladaria Kimball. Is that correct?
Yes, Your Honor. Yes, Your Honor.
All right. I'm going to go ahead and put the iPad in room 1. All right. And Mr. Cade, are you driving?
Yes, I was gonna pull over once you call my case. It's just,
All right,
I knew,
you should pull over and then I'll call your case after you've pulled over. All right, sir?
Okay, good deal. Thank you, sir. Thank you, Your Honor.
And in the meantime, we'll go with Mr. Nixon's case. So, Mr. Hopkins, you can come up here.
Can I leave my stuff here?
Sure. All right, we're on the record in 26000857. That's JP Morgan Chase Bank versus David Hopkins. Appearances for the record, Mr. Nixon.
Alfonso Nixon, key 83746 on behalf of the plaintiff, Your Honor.
All right. And sir, you are David Hopkins. Is this correct?
That's correct.
All right. Thank you. This is the time set for a pretrial in the matter. I generally give people the opportunity to speak before the pretrial to discuss any of the legal issues led to filing a complaint. I think our one iPad is being used right now. I don't know that we have a second iPad. We may have a second iPad if you choose that. If not, I can do a pretrial schedule, which is really a scheduling order concerning this matter. Mr. Nixon, you are the moving party. How would you like to proceed?
Your Honor, I do believe that given the low balance in this matter, we may be able to reach a resolution. If you would like to, for efficiency's sake, complete the scheduling order and then place us in the breakout room, we can have our conversations and we won't impede the court's progress.
Yeah, Mr. Hopkins, are you interested in speaking to Mr. Nixon about resolving this case?
I had a pre-legal attorney. And when I mentioned how much I could afford, she said they'll never go for it and said goodbye to me.
All right, so I'll just do the pretrial statement. You can always talk later, but I'm sure your phone number or your contact information is on the complaint that's been filed. Is that correct, Mr. Nixon?
It is, Your Honor.
All right, so let me do the pretrial statement. I'm going to give you the opportunity to see what we're doing here, and then you can sign it, okay?
This is all new to me.
All right, so exactly why you're going to get to see what I do, okay? We're going to put it on the record, and we're going to see. So this is a pretrial statement on 26000857. And that is JP Morgan Chase Bank versus David Hopkins. And JP Morgan Chase Bank is represented by Al Nixon today. And Mr. Hopkins is here in pro per so that you're representing yourself.
It's going to be the same as it was before, Your Honor, that I don't have the money to be able to pay.
All right, that's a different issue. This is a pretrial on the complaint.
Yeah.
But that may come concerning a motion for summary disposition later, but we're going to address that. On the pretrial statement, I usually use blanket language as a breach of contract. Is that what we're dealing with, Mr. Nixon?
It's a simple collections matter, yes, Your Honor.
Okay. So I'll put collections and then breach of contract. That's the nature of the allegations been made is that it's a collections matter, breach of contract. I'm going to hold on to the motion for summary disposition, which is motion as a matter of law, and the response. In response, do you anticipate any further pleadings in this matter, Mr. Nixon?
Outside of a possible MSD, I wouldn't expect further pleadings at this time, Your Honor.
All right. And then I've held back on the motion for summary disposition response. Those won't be filed at this point in time, but they may be filed before discovery. It's up to the litigants, and that goes for your response too. You'll have the opportunity to respond to the motion for summary disposition. Other than those two pleadings, none is anticipated.
I don't anticipate anything further. in my familiarity with the defendant, I believe this matter can be worked out. If the court can allow the parties 60 days at the most to
All right.
to a resolution and get a stipulation to the court.
All right. So what we'll do is we'll set discovery out 90 days and allow the parties for contact, and that should suffice. I'm going to issue that we're not consolidating this with any matter. The admissions of fact are not applicable because we've not had any discovery in this matter. The exhibits are not applicable. Discovery process will go for 90 days. What's my date on August?
Can I say something, sir?
You can. We're just setting this out for discovery. And in the meantime, the parties can talk.
My only source of income is Social Security.
That'll all be worked out by the parties, but it's so August, let's see, August.
5th is 90 days.
Okay. So set for August 5th?
Well, am I actually setting something?
No.
No. Oh.
No, and no, you're not. So that's set for discovery. Discovery is 90 days out. On August 5th is the date. I'm going to indicate that expert witnesses are not anticipated. Damages have been pled for. I'm going to say that the joinder of claims is not anticipated at this time. Mr. Nixon, did you pay for a jury trial in this matter?
We would not be requesting a jury trial.
All right.
Mr.
Hopkins, if you paid for a jury trial in this matter.
I don't know what that means.
All right. So it'll most likely be a bench trial in front of me if it's scheduled. And the estimated trial, I would say would be a half day. And we'll set it after. Yeah, we'll set it after discovery. Possibility of settlement negotiations are continuing. And I'm going to place no on evaluation and no for mediation at this time, and the parties can let me know. Mr. Nixon, do I have your authority to sign this via your behalf on Zoom?
Absolutely, Your Honor.
Okay. All right, and then Mr. Wormsley, I'm going to have you take the pretrial statement to Mr. Hopkins.
Okay.
There's a place for the defendant to sign, and you can look this over. All we've done is we've set the discovery for August 15th. That's a chance for the parties to trade information, and everything else is not anticipated at this time. We also, Mr. Wormsley has the iPad now, and so we could place you on an iPad if you still want to speak to Mr. Nixon just concerning some of the settlement offers or negotiations concerning this matter.
I don't think he's going to accept anything I'll offer.
All right. So let's do the pretrial statement.
And that's going to be on 8/15/26 at what time?
It's just the time. 8/15/26 is just how the 90 days for discovery. So there's no hearing set.
So I don't have to come down here again.
Correct. Yeah. That's how long the parties have to negotiate and to exchange information.
I wish I understood any of this, but I don't.
But what don't you understand?
Any of it.
Just read it to me. Read what you don't understand to me.
I need new glasses, so
you can't see what we're doing.
Reading.
Do you want me to read that to you?
Sure.
Okay. So this is a pretrial statement on 26-00857. It's JP Morgan Chase Bank versus David Hopkins. A pretrial conference was held on May 7, 2026. Do you need any of that explained to you, sir?
I guess not.
Okay, appearing were Al Nixon via Zoom and David Hopkins. For the defendant, you're in pro per. Any issues are a breach of contract is what they're alleging. They're only alleging breach of contract. It's a collections issue at this point. Do you understand that, sir?
I do.
Okay. The pleadings they're holding on to, that the court's holding on to, are motion for summary disposition, which is a motion as a matter of law, and your response. It hasn't been filed yet. That's the only one I'm holding on to. Do you understand that?
I have to trust that you're saying it right. I don't know.
Yeah, well, for motion for summary disposition, it's just, they're indicating that they would file a motion and then you would get the motion and you'd have the opportunity to respond to the motion. Do you understand that? It hasn't been filed yet. It could be filed.
I see.
So do you understand that?
Yes.
Okay. At this point in time, we don't anticipate any further pleadings or motions. Is that a fair statement, Mr. Nixon?
Absolutely, Your
All right. There's no anticipated consolidation with any other cases. I placed a not applicable as to the admission of factor exhibits because we haven't gone through discovery yet. So they don't know if there's an admission of factor exhibits, and you don't know because you haven't provided them with any discovery. Do you understand that?
What is it they're trying to discover?
They could financial banking records. They could. It all depends on what they're asking, but usually it's for financial records or employment records.
What I heard earlier.
Correct.
I understand that.
And none of that's applicable because we haven't finished the discovery process. So that process isn't going to be finished till 90 days till August 15th.
Do I get something in the mail showing this?
You're going to get a copy of this.
Okay.
Yeah, you're going to get a copy of this after. It depends on whether it has no. You can get a copy of this. You can sign it if you'd like to. Okay. The expert witnesses are not applicable. The damages have been pled for in the initial complaint, and the possibility of settlement or negotiations are continuing. I should finish writing continuing. My penmanship. The nature of trial is a bench trial in front of myself unless somebody's paid for a jury trial or sought a waiver. And at this point in time, we don't have a waiver, so we're just doing a half-day bench trial. I'm not ordering evaluation or mediation at this time because the parties aren't requesting at this time any type of evaluation or mediation. Mr. Nixon's allowed me to sign his name via Zoom, and then you can look at that. That's the only thing, and then you can get a copy of that.
Thank you. Right here?
Yes.
Yeah.
All right, I will sign the pretrial statement as sitting judge. That's 5/7/2026. And then I will provide a copy. We'll provide a copy for Mr. Hopkins so he has it and keep it on his records, okay? Anything else for the record in docket 26000857, Mr. Nixon?
No, that'll be it, Your Honor.
All right. We'll provide a copy for your records. Thank you for your appearance today, Mr. Hopkins.
Can I ask one more question?
Sure.
On my calendar at home, it says that I have an appointment down here on May 18th. When I called, they said nothing's booked. I don't have any paperwork that says that I'm supposed to be here.
Let's see where your name comes up on the computer on May 18th. Okay. We don't have it either. So if you've received nothing and
That's when you're gonna be out.
yeah, and you won't be in this court because I won't be here. Okay, so you should be all set, Mr. Hopkins. It's not a bad idea to call before, but that I have that date. I'll probably most likely not be here. I won't be here. That's the 18th, right? Okay.
Just looking to see.
So this date of 90 days, I'm not sure what that's all about.
It's an illusory date. There's no actual hearing date. It's just that's how long discovery goes forward for that 90 days.
If they send me something to fill out, I can give them my credit union and
yeah,
bank statements.
Whatever terms that they wanted part of discovery, and you have the same with them. All right, you should be all set, Mr. Hopkins. Thank you.
Appreciate it.
All right, and then Miss
Henry.
I'm losing track of my cases. Miss Henry, Latia Henry, correct? All right. And then Mr. Smith. So we're back on the record in docket 250291. And that is Lafcue versus Latia Henry. And Mr. Smith, did you have the opportunity to speak with Miss Henry in a breakout room?
I did, Your Honor. We discussed what a conditional dismissal with payment plan could look like, and I believe have agreed to terms. I gave her today's balance on this account of $3,396.28. I said that we would accept monthly payments at $100 per month beginning June 1st. And if those terms were acceptable, and that interest would run at the contract rate during the payment plan. And if those terms were acceptable, we would conditionally dismiss the suit. Ms. Henry was agreeable to those terms. What I'd like to do, just to make sure, is I'm going to email her tomorrow a copy of the order of the proposed
All right.
stipulated dismissal. I'd like her to review it. She could seek independent counsel. If she has questions, she could call me with questions, but I'd like her to see it first before we sign and submit, Your Honor.
All right, and I think that's a fair statement, Ms. Henry. He'd like you to see the agreement, to know what you're agreeing to. You can sign it and send it back to him, and then it will advance to the court.
Yes, he said, I'll sign it. I'll say, I have received it, I understand it, and I'll allow him to sign for me.
Perfect.
Correct.
Perfect. All right, so that is the nature of the agreement, is that you would say, I've read it, I have authorized any signature on your behalf, and that'll be forwarded to the court.
Yes, sir.
Okay. All right, I will await, so the parties have reached the conditional dismissal, and I will await the order to follow. And that'll be submitted by yourself, Mr. Smith, is that correct?
No, that is correct, Your Honor. Thanks for the help today. And thank you, Miss.
All right.
Appreciate you.
Thank you.
All right, so we should be all set on that file. I'll wait the order to follow concerning docket 2507291. Ms. Henry, do you have any questions of me?
No, sir.
You should be all set. Thank you, ma'am.
Thank you. Do I wait for paperwork?
I don't think, wait for paperwork to be sent by email from Mr. Smith.
Okay.
Okay.
Okay. Thank you.
Thank you.
Have a good day. Have a good day, Mr. Smith.
You as well, Miss Henry. Your Honor, I think that wraps up my afternoon docket. Appreciate the help.
All right. Thank you, Mr. Smith.
See you, Judge.
All right. And then we'll call your case, Mr. Cade.
Okay, Your Honor. Oh,
All right, so we're on the record in docket 250655R. That is Edward Cade versus Ladario Kimball. Appearances for the record, sir, you are Edward Cade, is that correct?
yes, Your Honor.
All right. And sir, you are Ladario Kimball, you'll have to unmute.
Yep.
All right. Thank you. So let's see. I'm on the wrong one. Let's see. All right. So Edward Cade and Ladario Kimball have appeared for their pretrial. I do give the opportunity to the parties to speak to one another, or I can just fill out a pretrial statement. Mr. Cade, you are the moving party. How would you like to proceed today?
Well, I just fill out a pretrial statement, Your Honor. We've already spoken. Mr. Lodaro's already broken several promises. I just want this thing over with. Any
All
other
right,
conversation, it's just another promise broken.
All right, so we will have the pretrial statement on 25-066. I'm sorry, 25-06556R. 0556R. That is Edward Cade versus Ladario Kimball. Pretrial was held on today's date, 5/7/2026. Appearing were Edward Cade, and that's in pro per, which means not represented, and Ladario Kimball. Also in pro per and not represented. How would you describe the issues that filed this complaint, Mr. Cade?
The issue is that me and Mr. Ladero had reached a settlement. He gave me some dates, and he hasn't come through with those dates. So that's why we want to proceed.
So this is a breach of contract.
Yes, yes, yeah. At this point, it is. It's a breach of contract now.
All right, I will hold back on a motion for summary disposition, which is a motion as a matter of law, to be filed by Mr. Cade if he chooses, and the response, which should be by Mr. Kimball if he chooses. Do you anticipate any further pleadings in this matter, Mr. Cade?
I'm not, to be honest, I'm not sure about how this process works. So I guess I have to do some research on my own about my next position here to get this thing brought in front of you, so you can finally figure out when I'm going to get paid or not. I don't know what the next process is. I guess I have to look up summary disposition and then move on that. I just want to get this thing before you.
All right, this is a matter of, I've held back on the motion for summary disposition and the response. I'm assuming that's a motion is a matter of law, and the response. So at this time, none's anticipated. We'll keep it open, but I'm going to put none anticipated at this time.
Okay.
And Mr. Kimball, do you expect any more pleadings or motions other than the response to the motion for summary disposition?
To be honest, none of this really matters to me anymore. So
all right.
We could actually, all he wants, to be honest, Your Honor, we could clear this today is a something on paper. That's what he's wanting. So if we can clear that today, we could be done with it today. That's all he could have just said that from the beginning.
But he doesn't want to meet with you. So any negotiations can be between, you can always talk to one another. I'm here for the pretrial statement.
That's already been done, and he hasn't honored his agreement already. So that's why we want to move forward.
I'm going to place that there's no cases to be consolidated in this matter. The admission of fact is not applicable. The exhibits are not applicable. We will set discovery 90 days out.
Okay. So you can just let me know the dates. 5th. Just let me know. You can just send me and let me know the dates.
Yeah, you'll get a copy of this sent to your last known address with the court. That's for discovery purposes, so there's no hearing date set yet. That'll be set by the civil department. This is only for you two to exchange information. That I've set discovery for 90 days, so it'll be set sometime after August 5th.
That'd be great.
Expert witnesses are not applicable. Damages have been pled for.
Your Honor, you could give him whatever he wants right now, and if I don't want to pay him, he wouldn't get it.
Well, I can't, because you're only here for the pretrial statement. So,
no, I understand that. I understand. I'm just he just don't understand. He thinking I'm going to stay in court.
So, Mr. Cade, have you paid for a jury trial in this matter?
I paid for whatever fees to bring him to court to get my money, and that's all I'm waiting for. I don't know what all this other stuff is with him. All he has to do is just pay me, and we're done.
All right.
Simple.
And Mr. Kimball, you've not paid for a jury trial, is that correct?
Nope.
All right. So we have an estimated time of trial of a half day. It'll be set after discovery. Possibility of settlement. Our negotiations are continuing. I'm not going to set for case evaluation or mediation, because it appears that neither party wants another party to sit and mediate the case. Mr. Cade, may I sign this on your behalf via Zoom? I've only indicated that discovery is 90 days out as far as the change of information, and I do not anticipate any other motions or pleadings other than I've held on to a motion for disposition and response that may be filed at any time.
Yes, Your Honor.
All right. And then, Mr. Kimball, may I sign this pretrial statement on your behalf for the defendant?
No, go ahead. I don't care.
Okay.
Oh, no, wait, I am, what you mean for the defendant?
Yeah,
Oh
you
my
are,
God.
you're authorizing me to sign it on your behalf.
Oh, okay.
All right, I'm gonna sign this as a sitting judge. You may get, this will eventually be set by the civil department for a hearing to be set. If a hearing is set by the civil department, you should bring in any evidence you want the court to consider, all right, Mr. Cade?
Yes, Your Honor.
And Mr. Kimball, do you understand that? You should bring in any evidence you want the court to consider, all right, sir?
I don't care if you rule in his favor right now.
Okay.
I really don't, because he think it's not gonna go the way he think it's gonna go.
All right,
care.
so we're on the record in 25-06-556R. I've signed for the parties, and I've signed it as district court judge. You can get a copy sent to you from the civil department. It'll be on record there. Anything else for the record in 25-06-56R, Mr. Cade?
No, Your
Honor. Anything else, Mr. Kimball?
Nope, love you, killer.
All right, you're all set. Thank you for your appearance today.
Bye-bye. Thank you.
We can leave?
Yes, you're free to go.
Thank you, Your
How
Honor.
the hell you get out of
Thank you, Mr. Cade.
Sorry.